Mississippi State Board of Medical Licensure meeting to order. We will start with well, first of all, I'd like to welcome our court reporter, Amy Key. Also, our special assistant to the Attorney General's office, Sarah Hartzog, and also our new consumer member from the wonderful Delta of Mississippi, Greenville, Ms. Tamika Simmons. This will be your first meeting, so welcome aboard. And but not his first meeting. You only get the introduction on your first meeting. Oh, and also Dr. Rish, who is our physician member. He will be taking the oath of office momentarily. We'll begin with a invocation done by Dr. Loper. So we'll stand for that, followed by the Pledge of Allegiance.
Bow their heads. We can remember to the presence of our Lord and Savior. Dear Heavenly Father, we want to just give you all the glory and thank you for this opportunity you give us today. Thank you for letting us serve the people of the great state of Mississippi. May our deliberations today be both glorifying and edifying to you. And as usual, safe travels as we return home today. In Jesus' name we pray. Amen.
Amen. Thank you. We'll face the flag. I pledge allegiance to the flag
of the United States of America and to the republic which stands one nation, under God, indivisible, with liberty and justice for all.
How you doing? Okay, moving right along, we will have the oath of office. Dr. Rish and Ms. Hartzog, would you do the
Do we go up here?
Yeah.
Doctor.
honors?
We solemnly swear or affirm that I will faithfully support the Constitution of the United States and the Constitution of the State of Mississippi and obey the laws thereof, that I am not disqualified from holding the office of member Mississippi State Board of Medical Licensure, that I will faithfully discharge the duties of the office upon which I am about to enter. So help me God. Congratulations.
Okay, are there any public comments? Okay, seeing that there are none, we'll do the report from the Executive Director, Dr. Cleveland. I'm sorry. Yep, roll call first.
Yes, yes, thank you. Dr. Givens.
Present.
Dr. Kennard.
Present.
Dr. Roth.
Present.
Dr. Rish.
Present.
Dr. Gersh.
Present.
Dr. Dotson. Dr. Loper. Dr. Latore.
Present.
Dr. Owens.
Present.
Ms. Games. Mr. Moore. Ms. Simmons. Mr. President, you have a quorum.
Thank you. And then request public comment. There were none, so we'll move on to the report from the Executive Director.
Thank you. So, continue to issue a lot of licenses. And of course, this time of year is probably one of the times of year we do the most with all the transitioning from June to July and movement of physicians and new graduating positions, et cetera. So 195 MD/DO licenses were issued over the past 2 months. No new podiatrists and 28 new PAs, one administrative license. Through the compact, which has been very good to the state of Mississippi, we licensed 243 additional physicians. We provided 6 letters of qualifications for Mississippi-based physicians to join the compact and to be able to get multi-state licensure. And to other states, we gave certifications to 347 physicians. This is a look at renewals. You know, May and June is our renewal period. I will just go to the percentages instead of going through all the different numbers. We had a very high percentage rate. Comparatively, really, it's probably almost the same, I should say. But in the 90s, for the most part, throughout all license types, with the highest being the podiatrist re-upping. In investigations, we received 108 new complaints, a pace that is pretty average these days. We were able to close 19 cases, opened 18 new cases, giving us a total of 59 cases, and then closed within 7 days. That percentage is down, probably because of the executive director's absence from the office for a period of time. But so I'll take the heat on that one. We requested 132 PMPs. Additional action was taken on 50 of those. Regulatory compliance meetings, we had 2 of them over the past couple of months, and we had no recidivism appearances. I just want to point out once again, we have a full complement of consumer members now. Mr. Moore, Miss Simmons and Miss Games. Thank you. I'm sorry. My mind blanked on me there for a minute. You were sent a link to take a survey, and that survey, the report I'm getting is that about half of y'all have done it. Since it is a confidential survey, I don't have any idea or how to tell which half of y'all have actually done it. So I'm just asking that the other half of you get that done. And I've got a QR code that I can pass for you to be able to do that at some point today, if that's convenient for you. Just a reminder, we have the retreat coming up next month. For those of you that want hotel reservations, you need to make sure you have let Frances know that you need a hotel room so she can make those arrangements for you. We are continuing with our outreach program and trying to get out there and make ourselves available and make sure people understand what a Board of Medical Licensure does. Of course, our licensees, for the most part, understand that. The picture on your left there is me presenting to CME in the sand. I think a few of y'all were probably there for that, and I think that went rather well. In addition, on the right here, you can see our licensing director, Anna Boone, talking with PA students and future PAs and walking them through the licensing process and helping them understand what their requirements will be when they graduate. So there is now a link on our website where somebody can go and request a speaker. And that can be pretty much any of us. It can be one of our attorneys. It can be me. It can be Jay Ledbetter, licensing director, investigations director, whatever is their choice. And we will try to make arrangements for that to happen. In addition to that, we have started our social media campaign. And so as many of y'all as possible would start to follow us on Facebook, if you're on Facebook or Instagram or LinkedIn, so that you can get those posts and like them and try to make us more popular than we are right now. That would be great. And with that, I'll take any questions.
Okay, seeing there being no questions, then we'll move to the approval of the minutes of the executive committee. That would be actually from May 21st. So we'll hit those first if you had a chance to review those in your packet, and I'll entertain a motion.
So move, Carlos.
Okay.
Second.
Motion second. All in favor?
Aye.
Okay, then we'll look at approval of the minutes of the board meeting, May 21st. Have a motion,
Motion to approve.
second?
Second, Carlos.
Okay, all in favor?
Aye.
Okay. Mr. Roth, if you'll provide us the report of the executive committee meeting of my July 15th, which was this morning.
Request of a Dr. DeBaria for an exemption.
Oh, wait, you want to get your microphone?
So the first was the request of a Dr. DeBaria for an exception to the exception to the ACGME accreditation in our bylaws. That was denied. Dr. Lisa Bond for a mileage exemption for supervision of APP. That was approved. A Dr. Green approved for a mileage exemption was approved. Dr. Arjal asked for an exemption of the 80-20 rule and supervision mileage rule. That was tabled to our September meeting so that Dr. Cleveland can get some input from the board to ask some questions and they can report back to us in the September meeting. Dr. Levy, the next one was an exemption for the mileage rule. He's getting deployed to a different state. That was approved. Number 6 was a physician, Grady, asking for an exemption for the 80-20 rule. That was denied. And the last was a Dr. Thompson asking for a mileage exemption for his vascular lab, and that was approved.
Thank
That's all
you.
we have.
Thank you, sir. Appreciate that report. Okay, we will now move to the, oh, that's right. Motion, I'm sorry, yeah. Motion to approve minutes from the actions of the executive committee meeting. Thank you. Dotson. Okay,
Second.
all in favor?
Aye.
Okay, good. Thank you, ma'am. Appreciate that. Now we will move to the, well, like hearing in the case of John Marley Bernard, consent order.
Good morning.
Morning.
We are here on asking for approval of a consent order for Dr. John Marley Bernard. He is appearing by Zoom, and his attorney, Jeff Moore, is also on Zoom with him. We ready to proceed?
Yes, please.
Dr. Bernard, can you please state your full name for the record?
John Marley Bernard Jr.
I didn't know we had.
And what is your primary area of practice?
I am board certified in emergency medicine, and I do some telemedicine work as well.
Sorry, I got a little ahead of myself. Let me get you sworn in by our court reporter.
Would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your name for the record again?
John Marley Bernard Jr.
And what is your primary area of practice?
I'm again was trained and went through residency and board certified in emergency medicine, and I do telemedicine work as well.
And where are you currently employed?
I am employed mostly at a hospital emergency room and observation department in Toms River, New Jersey. But I also work part-time for a telemedicine company.
And do you reside in New Jersey full-time?
I do.
Is it true that you previously provided services for a telehealth company called Chiral while you were also working for Beyond MD?
Yes,
And is it true that you previously collaborated with a Mississippi licensed APRN named Holly Hall, who's based out of Manhattan, Kansas?
that is correct.
And is it true that she also provided services for Chiral?
Yes,
Do you understand that you violated the board's collaboration regulations by failing to practice 20 hours per week or 80 hours per month within the state of Mississippi while collaborating with this APRN?
yes,
And do you understand that you also violated the board's collaboration regulation by collaborating with an APRN that was located more than 75 miles from you?
yes,
And do you understand that your failure to report your collaborative relationship with APRN Holly Hall to this board was also a violation of the board's regulations?
yes,
And do you understand that any violation of the board's rules and regulations is considered unprofessional conduct?
yes,
Do you understand that you have a right to a hearing in this matter, but have agreed to accept this consent order in lieu of a hearing?
yes,
And do you understand that under this consent order, you are accepting a reprimand and have agreed to take a CME course in ethics to resolve this matter?
yes,
And do you understand that you'll be expected to reimburse the board for all investigative costs related to this action?
yes,
And lastly, are you asking the board to accept the consent order as it is written to resolve this matter?
I am.
I have no further questions.
Ms. Geis, do you want me to ask any questions, or is the board just going to take this under consideration now?
Hi, Mr. Moore. I'm Sarah Hartzog. I'm the Special Assistant Attorney General and Hearing Officer. I was to Dr. Givens just turned the reins over to me, so sorry about that. Yes, if you have any questions for your client, you may proceed at this time.
All right, thanks very much. Dr. Bernard, of course, you know I've been representing you in this matter, and we worked through a consent order with the board, and with counsel for the board, and I know the board is looking at that today to consider whether it will approve that consent order. Dr. Bernard, did you intentionally violate the supervision requirements for nurse practitioners in Mississippi, or was it simply a matter of your not understanding the rules?
It was a matter of my not understanding the rules. I did not intentionally violate them, no.
And was someone else actually assisting you in that process to make sure that your collaboration agreement was in place, and did those folks actually misunderstand the rules?
That is correct. I was, again, going through this collaborative arrangement through a telemedicine company, which apparently failed to send in the appropriate information to the Board of Medicine. That's my understanding of what happened.
Right. But you do admit, as you did a moment ago, that we didn't comply with the 20/80 hourly requirement or the distance requirement because we didn't understand those rules.
That is correct, yes.
All right. And Dr. Bernard, would you tell the board where all you hold medical licenses, and approximately how long you've held multiple medical licenses?
I am licensed in all 50 states and in Washington, D.C. My first medical license was in the state of New York, actually, and that dates from 1997. And I guess right around COVID, when telemedicine, became more accepted and popular, I then applied for pretty much all the state licenses within a span of about 4 or 5 years. So my last license that I received was, I think it was probably Hawaii, truthfully, and that was about 3 years ago.
And you you have all those licenses so that you can practice via telehealth or telemedicine. Is that correct?
That is correct, yes.
And in all the years that you've held those licenses, have you ever had any type of sanction by any other state board of medical licensure, or by any hospital where you hold privileges, or by any trade association that you may be affiliated with?
I have not, no.
So this will be your first, I guess, sanction as a practicing physician.
That is correct.
Okay. Those are all the questions that I have. I just wanted the board to hear that and know that, you know, Dr. Bernard certainly intends to comply with the rules. He did not comply with the hourly requirement here or the distance requirement, but he's got a very good record across the United States, and I hope that the board will take that information into consideration as it considers the consent order.
Okay, thank you, Mr. Moore. Does the board have any questions?
Okay, no questions.
Okay, I'll turn it back over to you, Dr. Givens.
Okay,
I'm sorry.
No question. I was just waiting.
okay. Okay, thank you. Okay, all right, we've heard information approved. Do we have a motion for approval of the consent order?
So moved.
Second, Michelle Owen.
Okay, all in favor?
Aye.
Aye. Okay, motion carries. Approval of consent order granted. Thank you.
Thank you.
Thank you.
Thank you.
We'll move to the hearing in the case of Dr. Asad Khan Niazi, approval of consent order.
Dr. Niazi is also here appearing via Zoom, and his attorney, Natalie Heineman, is also on Zoom with him. If we could get Dr. Niazi sworn in.
Yes, please proceed.
Doctor, please raise your right hand. You solemnly swear or affirm that the testimony about to give today will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Dr. Niazi, can you please state your full name for the record?
Sure. It's going to be Asad Khan Niazi.
And what is your primary area of practice?
So I'm an internal medicine physician by training, but I also do telemedicine as well, full time.
And where are you currently employed?
At Shed RX
And where do you reside?
in Houston, Texas.
Is it true that you signed an agreed order with the Washington Medical Commission for acts of unprofessional conduct related to misrepresentations on your application for licensure in the state of Washington and for violations of Washington's medical cannabis regulations?
I do, yes.
And is it true that under that consent order, you agreed to undergo a fitness to practice evaluation and agreed to have several restrictions placed on your license in the state of Washington, including a telemed restriction and a medical cannabis restriction to resolve that disciplinary action?
I do, yes.
And do you understand that the action taken by the Washington Board constitutes action against your ability to practice in another jurisdiction, which is a violation of the Mississippi Medical Practice Act?
I do, yes.
Do you understand that you have a right to a hearing in this matter, but have agreed to accept this consent order in lieu of a hearing?
Yes, I do.
And do you understand that under this consent order, you are required to comply with all of the requirements set forth in the Washington agreed order?
I do, yes.
And do you understand that under this consent order, you are restricted from practicing telemedicine with patients located in Mississippi?
I do, yes.
And do you understand that under this consent order, you are permanently restricted from issuing written certifications for medical cannabis to patients located in Mississippi?
I do, yes.
And do you understand that you must provide this board with proof that you have satisfied all the requirements of Washington's agreed order before the telemedicine restriction on your Mississippi license can be lifted?
I do, yes.
And do you understand that you'll be expected to reimburse the board for all investigative costs related to this action?
I do, yes.
And are you asking the board to accept this consent order as it is written to resolve this matter?
I am, yes.
I have no further questions.
Ms. Hartzog?
No questions from me, thank you.
Okay. Any questions by the board?
Okay.
Okay.
Seeing there are no
Alrighty.
questions, I'll look for a motion to approve the consent.
So moved.
Second.
Approve second. All in favor?
Aye.
Thank you.
Any opposed?
Any opposed? No. Okay. Consent order approved. We'll now move to the hearing case of Dr. Matthew Tipton. Approval of consent order.
Dr. Tipton is also appearing via Zoom, and his attorney, Doug Mercier, is here in person. If we could get Dr. Tipton sworn in.
Do you solemnly swear or affirm that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth, so help you God?
You're muted.
I swear.
Dr. Tipton, can you please state your full name for the record?
Matthew Thomas Tipton.
And what is your primary area of practice?
I'm board certified in internal medicine, and I've worked probably 50-50 in hospitalist and emergency medicine since 2013, and I do a lot of prison work with MDOC now.
And where are you currently employed?
I'm a sheriff deputy in Alcorn County. I cover their county jail there, and then all the county and city employees in Corinth and Alcorn County. In addition, I cover the prison in Alcorn County, which is run by MDOC, and that's through a contract company called Vital Corps. I also cover them at about 5 other facilities throughout Mississippi.
And where do you currently reside?
I live in Middleton, Tennessee, which is about 15 minutes north of the Mississippi border.
Is it true that you signed a consent order with the Tennessee Board of Osteopathic Examination to resolve a disciplinary matter for prescribing and dispensing a controlled substance with an expired license?
Yes,
And is it true that under that Tennessee consent order, you agreed to be placed on probation for 1 year, were prohibited from supervising or collaborating with mid-levels, and were required to complete a CME in ethics and were fined $3,000?
that's correct.
And is it true that you also signed a consent order with the Texas Medical Board as a result of the disciplinary action taken by the Tennessee Board?
That's correct.
And is it true that under the Texas Board's consent order, you agreed to comply with all the requirements of the Tennessee order and provide proof of your compliance to the Texas Board?
That's correct.
Do you understand that the actions taken by the Tennessee and Texas boards constitute action against your ability to practice in another jurisdiction, which is a violation of the Mississippi Medical Practice Act?
I do.
And do you understand that you have a right to a hearing in this matter, but have agreed to accept this consent order in lieu of a hearing?
Yes, ma'am.
And do you understand that under this consent order, you are accepting a reprimand and are agreeing to comply with all the requirements set forth in the Tennessee order to settle this board's disciplinary action?
Yes, ma'am.
And do you understand that you must provide this board with proof that you have satisfied all the requirements of the Tennessee order before this consent order can be lifted?
Yes, ma'am.
And do you understand that you will be expected to reimburse the board for all investigative costs related to this action?
Yes, ma'am.
Are you asking the board to accept this consent order as it is written to resolve this matter?
I am.
I have no further questions.
Mr. Mercier, do you have any questions for your client? You can proceed.
Dr. Tipton, you just explained a little bit to the board about your current medical practice. There was a letter that you provided to me from the Alcorn County Sheriff's Office from Sheriff Ben Caldwell. Can you explain your involvement with the Sheriff's Department?
I served in 3rd Ranger Battalion for 5 years as a infantryman, and then when I got out, I became a paramedic. I immediately started working with a SWAT team in Tampa and providing tactical training to them for combat wounds and tourniquets and stuff like that. I did the same when I was in med school for the local sheriff's department. And when I got up here during residency, I became friends with one of the majors in the police department. And I started writing grants for them and helping them get body armor and tourniquets. At some point, I became a part of the SWAT team, and I've continued to work with first responders all over my community in Mississippi to help just better trained medics and firefighters and police officers. I'm also a fire captain in Hazelhurst, Mississippi, and most of what I do there is administrative, helping them write government grants and do airway training and stuff like that.
Thank you, Dr. Tipton. No more questions.
Any questions by the board? No, hearing no questions, I'll turn it back over to you, Dr. Givens.
Okay, thank you, ma'am. I'll entertain a motion for approval of the consent order.
So move.
Motion to approve, second, Owen.
Okay, any opposition? Okay, all in favor?
Aye.
Okay, motion carries. Consent order approved. Thank you.
Thank you, ladies and gentlemen.
Okay. We'll move on to hearing in the case of Dr. Richard Rhoden, motion for continuance.
This will be the second motion for continuance in this case. He was originally served for our May meeting and got the initial continuance. Upon preparing for this hearing, our expert as well as the licensee's expert both had a scheduling conflict. So we are asking the board to grant this motion for a continuance to continue us until the September meeting.
Any questions from the board members? Okay, I'll entertain a motion for approval of continuance.
Move to approve.
Okay, motion approved, second. Any discussion, abstentions? Okay, most, all in favor?
Aye.
Okay, motion carries. Oh, yeah. Any opposed? No, okay, all set. So motion carries.
Yeah.
Okay, thank you, ma'am. We'll now, it looks like we have for informational purposes, something on Dr. Earl Maes.
Yes, just for informational purposes, Dr. Earl Blair Maes surrendered his license to practice medicine in Virginia. He pled guilty to violating 18 USC section 669, which is theft from a healthcare benefit program, which is a misdemeanor in the U.S. District Court for the Western District of Missouri. After he executed this voluntary surrender in Virginia, we asked him to surrender his Mississippi license on that basis, and he agreed to voluntarily surrender his license.
Okay, thank you. Is there any action we need to do on that?
That's
Okay, great. Okay, thank you very much. Okay, we'll move on with the hearing in the case of Dr. Michael Lawrence Sanders. And I'll turn it over to our special assistant.
Very special.
Very special, uniquely special.
Okay, good morning. Today's date is Wednesday, July 15th, 2026, and the time is 10:49 a.m. We are present at the office of the Mississippi State Board of Medical Licensure located at 805 South Wheatley Street, Suite 600 in Ridgeland, Mississippi. The matter on the docket today is the case of Michael Lawrence Sanders, Mississippi Medical License 15970. My name is Sarah Hartzog, Special Assistant Attorney General. And I will serve as your hearing officer in this matter today. My role during the course of this proceeding will be to rule on objections to questions or evidence raised by the party, to see to the orderly process of the proceedings, and to ensure that the proceedings are conducted in accordance with the applicable laws and rules. This is an administrative proceeding and not a court of law, so the formal rules of evidence and civil procedure do not apply to today's hearing. However, I may use both as a guide when ruling on objections or evidence introduced, but I am not bound by either during this administrative proceeding. So I'm going to ask the members of the board to introduce themselves for the record, and I'm going to start down here at the end with Ms. Gaines.
Renee Dotson.
Randy Roth.
Roderick Givens.
Kirk Kennard.
Michelle Owens.
Ellen Gersh.
Carlos Latore.
James Rish.
Thank you. And will the attorney representing the Board of Medical Licensure please state your name for the record?
I'm Paul Barnes, complaint counsel for the board.
Thank you, Mr. Barnes. And is Dr. Sanders here today? Hi, Dr. Sanders, welcome. And are you represented by counsel today?
Yes, I am.
Okay, who is your counsel?
Doug Mercy.
Good morning, Mr. Mercier. Nice to see you again. Okay. Let's see. We will go ahead and get down to business. Mr. Mercier, do you have witnesses that you wish to plan to call to offer testimony?
Call Dr. Sanders, and we're gonna have some witnesses be called by affidavit. It's already been entered for our matter and in this matter.
So Dr. Sanders and then affidavits?
Correct.
Okay. And then Mr. Barnes, do you have witnesses that you wish to call today?
Yes, ma'am. I'm gonna call Dr. Sanders as an adverse witness. And if necessary, I may call Jonathan Dalton, the Director of Investigations for the board.
Okay. Is Jonathan in the room? Oh, hello. Okay, Madam Court Reporter, will you please place the witnesses under oath? Okay, thank you so much. And then,
Not sure. I thought that Mr. Barnes was gonna call Jonathan Dalton. If he does not call Jonathan Dalton, I will be calling him as an adverse witness myself.
okay, that's perfect. Mr. Mercier, have you had an opportunity to review the board's exhibits? And actually, let me back up. Does the board have exhibits, Mr. Barnes?
The board does, and for the record, we're offering as a composite exhibit the following Bates number documents. And there is an index for this for the court reporter that we will provide you. But pages 1 through 5 are patient records from core cryotherapy. Pages 6 through 27 are records from protocols from core cryotherapy. Pages 28 through 68 are correspondence, both emails and texts, between Brent Holloway, Dr. Sanders, and on occasion others. Pages 69 through 114 are emails between Mr. Holloway, Dr. Sanders, and others. Pages 115 to 147 are collaboration documentation related to Dr. Sanders' collaboration with nurse practitioners at core cryotherapy. Pages 148 through 160 are financial documentation provided by Dr. Sanders from his time at core. Pages 161 through 170 are texts between Dr. Massey Headley and forget Ms. Brielle's first name. She has gotten remarried and her full name is in the record. I apologize. But those texts are pages 161 through 170. We have correspondence with Dr. Philippi from pages 171 to 73. We have copies of Dr. Sanders' credentials on pages 174 to 175. Dr. Headley's credentials are on pages 176 to 178. There are pharmacy documents related to various purchases and medications on pages 179 to 224. I'm not going to name the patient's names, but there are patient records on pages 225 through 252. From pages 253 to 447 are regulations from the Mississippi State Department of Health regarding emergency medical services. Pages 448 through 453 is a nurse practitioner collaborative agreement between Dr. Sanders and Ms. Priscilla Pulliam. Pages 454 to 456, patient records from core cryotherapy. Pages 457 to 458 are a timeline provided by Dr. Sanders. And then we have a series of affidavits. Page 459 to 460 is a statement, affidavit statement by a Justin Francis Cotto. Pages 461 to 463 is an affidavit of Kathy Graves. Pages 464 to 466 is an affidavit of Lauren Sharp. Pages 467 to 468 is an affidavit of Abby B. Calum, I believe, and that is Abby Brielle Calum. So that is the person. I could not remember her married name. Pages 469 to 470, it's an affidavit statement of a Miss Carrie Golston. Pages 471 to 485 are a collaborative protocol from Core Cryotherapy. 486 is a text between Dr. Sanders and Miss Pulliam. 487 to 491 is an affidavit statement from Miss Priscilla Pulliam. Pages 492 to 495 are text between Dr. Pulliam and Dr. Massey Headley. Pages 496 to 498 are strike that. We will not be offering pages 496 to 498, and we'll draw those. Pages 3129 through 3137 is the first amended summons and affidavit against Dr. Sanders. Pages 3138 and 3155 are the original summons and affidavit concerning Dr. Sanders. We are also not going to be offering pages 3156 through 3160, which are on your SharePoint, but we will not be offering those into evidence. Dr. Sanders' licensure application is on page 3161 to 3164. His renewal application is on 3165 to 3170. And his response to the first amended affidavit is on pages 3171 to 3175. I apologize for that lengthy list of numbers, but we have over 5,000 documents that could have been part of this case, and we were trying to clean this up as much as possible at the beginning. And I would ask, I've forgotten one thing. I believe Mr. Mercier has one document he wants to add. And I would ask Mr. Mercier to state whether he has any objections to our exhibits.
Well, let me proceed.
Yep.
So we have a composite exhibit we will call B1. Mr. Mercier, do you have any objections to the admission of B1, less the two groups of documents that Mr. Barnes has outlined? Do you have objections to the admission of those documents into evidence?
I don't have an objection to the ones that are being offered. I do have an objection to a withdrawal of 496 to 498 because I've been offered him, he's not, since
Okay.
I'm already in their compilation. Instead of pulling them out, making them a responded exhibit, if Paul doesn't have an objection, I'm going to offer that.
We'll offer that.
Okay.
496 and 498.
So exhibit B1 will be all of the documents identified in the exhibit list and on the SharePoint, less document number 3156 through 3160. Is that correct? Okay. All right. Do we need to have these admitted under seal to protect patient confidentiality, or are these significantly redacted?
At this time, we do, because there are patient records that would need to be, they're unredacted for the board's use, but we do need to be careful not to mention patients' names, and we would need to redact them substantially before we made them available to the general public. So I would ask that the board accept them under seal at this time for purposes of this year. I agree.
Okay. All right. So board composite exhibit B1 will be marked and entered into evidence into the record under seal. And then we have Mr. Mercier, you had exhibit R1, I believe. Is that correct?
Correct. We offer R1, which is a transcript of the May 18, 2023 consent order hearing for Dr. Massey Headley.
Okay. Mr. Barnes, do you have any objection to the entrance of exhibit R1 into evidence?
No objection.
Okay, hearing no objections, Exhibit R1 will be marked and entered into the record. Okay, any other preliminary matters that you would like to address before we proceed?
No, ma'am.
Okay,
Not from the licensee.
okay, thank you. All right, well, I know, Mr. Mercier, you are very well versed in the comings and goings of this board, but I will just state briefly that we will proceed as follows with opening statements. Opening statements are not required. They're not evidence and they're merely persuasive. Then we will hear evidence from both parties after the opening statements. In this case, the board does have the burden of proving the charges alleged, so they will put their case on first and will call witnesses. Mr. Mercier, as you're aware, you can cross-examine the board's witness if you choose, and the board attorney may conduct a redirect examination of the witnesses after your cross-examination. The members of the board may also ask questions as well. Once the board attorney finishes putting on his case, then it will be your turn to put on your case, and we will follow the same process. After both sides have concluded, closing statements may be provided. They are optional, they're not evidence, and they're not required. Then the board will deliberate and render its decision. We will give a summary of the board's determination today, and then we will send out a detailed written order in the mail within 30 to 45 days. Is there any questions about this procedure?
No question.
Okay, all right. Yes, sir.
I would like to remind everybody to turn off your microphones when they're not in use. They are a part of the speaker system. When your microphone's on, your speaker does not work. And additionally, we have one board member who is virtual. And so we need to make sure that we do turn on our microphones when we're speaking, especially the attorneys, when they don't get up to the podium, they're speaking from the table. You need to remember to turn your microphones on. Thank you.
Yes, sir.
Thank you, Dr. Cleveland. Okay, Mr. Barnes, we can proceed with opening statements.
Thank you, and may it please the board. This is a case involving a medical practice named Core Cryotherapy. Primarily, Core provided two services with some additions to the public. First, the Core offered testosterone replacement therapy, and second, Core provided IV hydration therapy. Now, as the board, some of the board members are aware because you were here, this is not the first hearing we've had about Core Cryotherapy, and that was also apparent from the fact that Mr. Mercier is going to enter a transcript from Dr. Headley's consent order hearing. I would like to say that the hearing for Dr. Headley's consent order, if you review the transcript, you will see that we were very, very careful not to elicit evidence about Dr. Sanders or against Dr. Sanders because both Dr. Headley and Dr. Sanders were entitled to their own individual independent hearings, which is required by due process. So briefly, this business was begun, it's my understanding, by a gentleman named Brent Holloway and his wife around the 2018 timeframe. At some point, a Dr. Massey Headley became involved with Core Cryo. At some point, he and his wife obtained an ownership interest of 50%, I believe, roughly 50% of the Core Cryo practice. Dr. Headley referred patients to Core, especially testosterone replacement patients from his primary clinic, which is part of the Baptist system. There was a medical director in that time frame, say 2018, 2019, I believe a Dr. Capel, Dr. Pell really doesn't enter into this matter. But around 2019, Dr. Headley and his business partner, Brent Holloway, decided that they needed to retain a new medical director. That medical director was Dr. Sanders. Dr. Sanders accepted the position of medical director for CORE and served in that capacity for approximately 2 years, or a little over 2 years, ending at some point in the spring of 2022. Now, CORE is not the first IV hydration practice that this board has had to consider over the last several years. But in many ways, it conducted its practice the same way that others have. It followed many of the same business practices and medical protocols that other IV hydration practices have used. And some of them are practices that this board has found deficient. Dr. Sanders and Dr. Headley overlapped at CORE. Dr. Headley, again, was a part owner, a silent partner. He was referring patients. Dr. Headley was certainly involved with advising mid-levels who were providing therapy and had other involvement in the operations of CORE. However, Dr. Sanders was retained as the medical director for CORE and served in that position for over 2 years. Amongst the things that Dr. Sanders did while he was the medical director, he allowed his credentials to be used to order supplies and medications to be used both in the hormone replacement therapy and the IV hydration therapy. Dr. Sanders did not personally perform any IV hydration therapy. At times, he had collaborative relationships with some of the mid-levels. The number of mid-levels and their identity changed. It was a revolving door. There were many different nurse practitioners, and at times there were no nurse practitioners at CORE, and yet IV hydration services were still provided, even though there was no practitioner there qualified to perform a physical examination, to take a history, to determine if there was a proper medical indication for IV hydration therapy, or to order the IV hydration therapy. That was all, at least partly, under Dr. Sanders' watch. The charges that the board brings against Dr. Sanders today are directly related to that. And the charges are not voluminous, but I do not want to speak inaccurately. There are 3 counts charged against Dr. Sanders. That Dr. Sanders is guilty of knowingly performing an act which in any way assists an unlicensed person to practice medicine by virtue of licensee's failure to oversee the use of medications ordered under his authority in violation of Mississippi Code Section 732529(8)B. Count 2, based upon the foregoing, licensee is guilty of prescribing, administering, or dispensing medications without a good faith prior examination or medical indication in violation of Title 30, Part 2640, Rule 1.4. And count 3, is a charge for unprofessional conduct, which is being based on the fact that any violation of this board's regulations counts as a separate statutory charge. So I'm going to call Dr. Sanders and ask him to discuss with me and with the board the way things actually went at CORE. Who was in charge? When was he in charge? When was he not in charge? And get down to the issue of who had authority for activities at CORE. I'm going to submit the evidence will show that both Dr. Headley and Dr. Sanders had authority and responsibility for the activities that went on at CORE. And at the end of the hearing, I will ask that you consider all the evidence, that you consider in keeping with the board's obligation not to reach an arbitrary and capricious decision, but to be consistent with other cases which have involved similar fact circumstances, and keep in mind the types and levels of discipline that have been given in similar cases, and find, if the board finds Dr. Sanders to be guilty of any of the charges, I'll ask the board to find an appropriate level of discipline for his personal responsibility.
Thank you, Mr. Barnes. Mr. Mercier, your opening statement?
Yes, thank you.
May I proceed?
Yes.
Good morning, ladies and gentlemen of the board. As you know, I'm Doug Mercier and I represent Dr. Sanders. I disagree with Paul and his intimation that these are the same facts as other cases. It's not. It's not the same facts as Dr. Headley's case, and we're going to demonstrate that. And it's wrong to try to throw Dr. Sanders in the same bucket with Dr. Headley and what he did. What you're going to see is in Dr. Headley's testimony under oath before this board, he admitted that he was a supervising physician for the people there at CORE, not Dr. Sanders, despite the fact that the board's counsel is going to attempt to portray Dr. Sanders in that light. I'm a pretty simple person. As a lawyer, I start with one thing, and that's a complaint when I'm defending somebody. And that's what we're going to go through. We're going to go through the complaint, the allegations that are made against Dr. Sanders by the board's chief investigator, Jonathan Dalton. And we're going to show that there's not been a violation by Dr. Sanders, because no matter what people want to think, what they want to presume, assume, the law requires this. And I think it's very important because we tend to forget it. The very first thing, and this is a quasi-criminal proceeding. That's what the law says in the state of Mississippi. An administrative proceeding like this is quasi-criminal. Dr. Sanders is presumed innocent at the beginning of this proceeding. The fact that a complaint is brought against him, no presumption of guilt arises from that. We start today. When we started this a few minutes ago, he is presumed innocent, and the burden of proving guilt is on the board counsel, not on Dr. Sanders or me to prove he is innocent. That's not the way it works. And in proving their case, the board counsel has to provide evidence to this board in the form of documentary evidence and testimony. And it has to be clear and convincing. Clear and convincing doesn't mean, well, I think that's probably true. Clear and convincing is just short of beyond a reasonable doubt. Like, yeah, that's strong. And we can present a lot of strong evidence to show his innocence, but that's not our burden. It's the board and the board's counsel to present that clear and convincing evidence. Dr. Sanders was not the medical director of CORE Cryotherapy. He signed an application for credit to the pharmacies over the line that said medical director at the beginning of his agreement to do something for Brent Holloway. At that time, Dr. Massey Headley was a partner in core cryotherapy, and he was already working there. He was referring his patients from Baptist there. And I'm not sure, I don't know enough about what was going on with he and Baptist, but that sounds like physician self-referral to me. But he was referring his patients from Baptist to core cryotherapy according to the affidavits of the nurse practitioners to treat those patients of his from Baptist the same as they were being treated at Baptist. They were going to treat him at core where he was a partner, although he was not a partner at Baptist. What was being done was this: instead of Dr. Massey Headley saying, okay, I'm a partner in this thing, Brent Holloway, and you can list me as the medical director, he's wanting to hide. No, don't put me out there as medical director. I don't want the feds and the state looking at me since I own a part of this thing and I'm referring my patients from Baptist here. Let's find somebody else. So Brent Holloway and Dr. Massey Headley found a friend of Brent Holloway's, Dr. Sanders, and asked him if he would help them. And he said, well, okay. And they wanted him to sign this credit application so they could order supplies. And at that time, core cryotherapy was in existence. And as I said, Brent Holloway was a partner along with Dr. Headley. During the course of this entire event with core cryotherapy, Dr. Sanders never saw a single patient there. That was not his job. That was not his role. He was not a medical director as tried to portray by Dr. Barnes, excuse me, Mr. Barnes. That was not his role in this. He saw no patients. He wasn't involved in the business of core. That was Brent Holloway and Dr. Headley. The cover-up is going to be apparent when you get to the affidavits of the people that were there. That's not me talking. You're going to see from the affidavits of the nurse practitioners that were hired and fired by Brent Holloway and Dr. Headley, not by Dr. Sanders. He had no role in hiring or firing anyone. Those nurse practitioners will tell you what went on there and that Dr. Sanders was not involved, but that Brent Holloway is the one they were told to speak with if they had any issue about a patient, they had any questions, to talk to Dr. Massey Headley, not to Dr. Sanders, which is what they did. It's in their affidavits. That's something that's sworn testimony. As I said, I start with a complaint. This is what we're here to defend. We're not here to defend whether or not Dr. Sanders parked in the wrong parking space and made somebody mad, or whether or not he submitted an application and he didn't dot an I, cross a T. It's what's in here, what he's been accused of by the board to enforce its regulations. It's a serious matter. And looking at it, in count one, the language is important. As we say in the law, words matter. These are the words of his charge. Based on the this is count one. Based on the foregoing, licensee is guilty of knowingly performing an act which in any way assists an unlicensed person to practice medicine by virtue of licensee's failure to oversee the use of medications ordered under his authority, all in violation of Mississippi Code Annotated Section 73, 25, 29, 8B. That's what he's charged with. That's what Mr. Dalton, Mr. Barnes have to prove. Each and every one of those elements, not just, oh, well, it sounds close enough. Every one of those elements has to be proven. They're not. Count two, based upon the foregoing, licensee is guilty of prescribing, administering, or dispensing medications without a good faith prior examination or medical indication in violation of Title 30, Part 2640, Rule 1.4, Maintenance of Records and Inventories of the Board's Administrative Code, all in violation of Mississippi Code Annotated Section 73, 25, 29, 13. You will not hear evidence And you will not see in any of the patient records before you that Dr. Sanders treated anybody there. You will not see that he prescribed any medication, administered any medication, or dispensed any medication at court. It's not there. I mean, this is a specious charge. It should be stricken right now because there's nothing, but we don't have summary judgment in these proceedings. Count 3, based upon the foregoing, licensee is guilty of unprofessional conduct, which includes being guilty of any dishonorable or unethical conduct likely to deceive, defraud, or harm the public, all in violation of Mississippi Code annotated section 732529 8D and 732583A. I apologize for going so fast. Again, there is no evidence of this outside of what the standard application is, and this is in every complaint, and the position of the board's attorney is if you violated anything else, we're going to say that you're guilty of unprofessional conduct because you violated another regulation. But he didn't violate any regulation, but that's what we're arguing about here today. You got a list of documents that have been admitted into evidence, documents from the board. These documents are basically, other than the affidavits of the people that were there that witnessed things, and of course the pleadings themselves, they do not prove that Dr. Sanders, let me go to the language, knowingly performed an act which in any way assists an unlicensed persons to practice medicine. It's not there. There was a case here. It was Dr. Headley. It was charged by the board for a lot of things, not the same charges as against Dr. Sanders. There are other charges. For whatever reason, the board agreed to a consent order based partly on what was presented to this board by Dr. Headley at the hearing that is transcribed as Exhibit R1. When you hear what the nurse practitioners said under oath in their affidavits who worked with Dr. Headley, and you compare that to what Dr. Headley told this board, you're going to be shocked and mad. You should be mad that you weren't told the whole truth about his involvement and what was going on. So now what's being done is they're trying to put blame on Dr. Sanders for really what was being done by Dr. Headley and his partner, Brent Holloway. Dr. Sanders was an innocent person trying to do a good deed to help a fellow, a person he knew, and he respected Dr. Headley at the time, and came to find out later on, after the fact, how he was being used, but he did not knowingly do anything to assist anyone to practice medicine who was not licensed. He was not the, quote, captain of the ship. He was not the head of the snake. He was not the top of the pyramid, as Mr. Barnes is going to try to make him. Just remember, it is not up to me or my client, Dr. Sanders, to prove he is innocent. That's not our burden. The burden is for the board to satisfy every one of the elements of the charge, not one, not two, but every element. And you're going to see it can't be done because it's not there. Thank you.
Thank you, Mr. Mercier. Mr. Barnes, you want to call your first witness?
Excuse me. My client witness needs some water. Y'all have some water you can provide? We do. Yes.
Oh, good. Thank you.
Please proceed.
The board calls Dr. Michael Sanders to the stand as an adverse witness.
Right here.
Dr. Sanders, I'll remind you, you've been sworn in already.
Yes.
Okay.
Thanks. May I proceed?
You may.
Would you please introduce yourself to the board?
My name is Dr. Michael Sanders, MD.
Please describe your medical practice, or do you have more than one medical practice?
Just one medical practice.
Okay, would you please describe that?
Well, I'm a family medicine doctor. I practiced with MEA Primary Care in Ridgeland from 2000 to 2011. I then left and became mostly administrative at St. Dominic Hospital. I worked just part-time as a hospitalist, maybe 2 weeks out of a year. I served in that capacity as medical director of care management. I served as the assistant vice president of medical affairs. I was twice the executive interim vice president of medical affairs for 6 months each time, 2013 and it going into 2016. I served as a chief medical information officer. I trained every doctor on Cerner, came up with every video, and it was used to train multiple hospitals, including River Oaks and Huntsville. I then decided I was going to switch careers. I became a certified physician executive at the middle of 2017. That was a culmination of about 4 years of work and 150 management hours. You might know one other CPE that used to be on this board. That's Dr. Claude Brunson. I finally, when I left, I decided I was thinking about doing direct primary care for a while, but I decided, well, I've done all this work in administration. So I applied as the executive director of the Mississippi State Board of Medical Licensure. I was one of the finalists. I interviewed on January 9th, and just one fact, I wore the suit on that interview that day as well. So I did interview. I did not get the job, but I was honored to be chosen just for the interview to be a finalist. And I decided to do this direct primary care practice, and I've been serving there for 8 years. I serve a lot of underserved patients. I dispense medicines. I'm licensed by the Board of Pharmacy to do that. And I serve as a hospice medical director as I've done for 10 years.
Okay, so what does your primary practice involve for the most part?
It's basic family medicine. I do all family medicine services. Chronic care, acute care, take off toenails, shoulder injections, knee injections, all the usual things that a family practitioner would do.
Okay, thank you. You do not perform IV hydration therapy as a part of your practice, do you?
No, I do not.
You never have performed that as part of your practice, have you?
No, I do not. Did not.
Do you have any training in IV hydration therapy?
No, I do not.
So you have never in your entire career ever assessed a patient, or let me strike that. Have you ever assessed a patient for potential IV hydration therapy?
I've dealt with typical patients in my office with elevated BUN, creatinine, or have come in dehydrated. If they're not sick enough to be in the emergency room, then I refer them to a local IV infusion with a doctor's order.
Okay. All right. So you would refer them to someone else who actually performs IV hydration therapy to carry it out.
They would be able to, it could be anybody, a nurse, an RN, anybody who could do IVs. They had to have my orders, but I would not have the IV fluids in-house, so I would refer them.
Well, that's curious. You mentioned anyone who could do IVs. Who can do IVs legally? Who can administer IVs legally?
Well, who can administer? I'm not sure I understand the question.
What medical professionals are qualified or authorized to administer IVs?
RNs can, and they have to have a doctor's order. Starting an IV is a very simple procedure. My understanding is that even EMTs in the field and paramedics can do so.
Okay. But you understand under Mississippi law that applies only to the field where an EMT or a paramedic is providing emergency medical services, correct?
I understand that you need an order, and that's what I was referring to. If I have a patient that I evaluate in my office, or a nurse practitioner can evaluate. They can order IV fluids. They have that authority to do it. If you're a nurse practitioner, you're already an RN, and you can start the IV and run the fluids yourself.
Excuse me, I apologize. Did you say that RNs are authorized to order IVs?
No, I did not. I said that all NPs, nurse practitioners, are RNs, and they can actually cross over and serve as an RN and start their own IVs. And there's actually nothing that would stop me from running my own IV if I wanted, if I had the materials in my clinic.
All right. But even though you don't include IV hydration therapy as a regular part of your practice, you had a past relationship with core cryotherapy, correct?
Yes.
Okay. Now, based on what your lawyer said, apparently you're going to say that your relationship included only signing a document for credit purposes to allow core to purchase medications and supplies. Did I understand that correctly?
If you're talking about signing some kind of contract or agreement with Core Cryo, I did not sign one.
But you signed authorizations that Core Cryo was able to use to order medications and supplies in your name from pharmacies.
I signed a credit application that requires a doctor's signature to open an account with supply companies, such as Medline, which they sell many things, bandages, supplies. Yes, you open a credit account. It does not authorize the use or ordering of those medicines to be used for any other purposes.
So is it your testimony that your credentials, your license number, your NPI, your DEA number were never used to order medications or supplies by Core Cryotherapy?
That's not what I'm saying. I'm saying that those things are required sometimes on the credit applications. That doesn't mean they are ordering controlled substances, which were never ordered here. Let me answer the question. These credit applications require some type of identifier, NPI, some use DEA, and these are required to open an account. At that point, the organization can order supplies. There's nothing authorizing those medications to be put in a single arm, a single vein, unless there is a nurse practitioner or somebody authorized who can write an order to do so, which is the example I was giving you when I order it out of my own clinic.
So who is required to order medications and supplies for use in a clinic? Is it a doctor, a nurse practitioner? Who can order?
Oh, that's overly broad.
Who can, I don't think it's overly broad.
Well, it's not relevant that we're talking about this particular incident in court.
It's absolutely relevant because your client just denied things that I can prove by documents in the record. Okay. All right. Dr. Sanders, when you order medications for your clinic, whose credentials are used as authorization for those purchases?
The reason the question is not clear because the account is opened up the account has to be opened up under the name to close a credit application. It's the confusion here, the confusion that this board needs to understand is that signing a credit application with the intent that it would be used appropriately under the only agreement I ever had, which is a collaboration agreement. That's not a problem for this board. If a nurse practitioner under that collaboration writes the order. I was brought in on the front end on a venture that I felt understood that this was going to be done by the books, that we were going to be done the right way. I was not brought in on the beginning to be in on a scheme to run an IV hydration clinic unmanned for anybody picking things out and wanting them ordered. That's the truth.
All right, Dr. Sanders, let's back up.
Okay.
Do you understand that a pharmacy cannot sell legend magic medications without a doctor's approval for the order of the medication, not the order of the administration, but for the order of the medication.
I do know this, that we have the evidence that there's plenty of Dr. Headley. We'll just show you. We'll show you the evidence. He ordered medications routinely, and this is in over 2.5 years of exhibits and in those statements that was taken by this board in November 2022 by Krista Garrett. We have the evidence, and we'll show it to you. We'll come back to this. I think we need to come back to this once we see who is ordering those medications under the account that was opened under my name. Yes, yes. Okay, can you ask the question one more time?
Okay. I may not get it exactly the same, but I believe the question was, do you understand that a pharmacy will not and cannot sell legend medications to a clinic without the authorization and credentials of a person with prescriptive authority, whether that be a physician or an advanced practice registered nurse? Are you aware of that?
Yes, I'm aware. That's what a credit application is for, in fact. It has to have a doctor's signature.
We'll look at some of these documents.
Okay.
All right, Dr. Sanders. And what you're referring to as a credit application, I'm going to represent to you and we'll discuss it. Apparently, we're going to have to really get into the nitty gritty of some of these documents. It's a lot more than a credit application. You've studied the texts and emails that you were involved in.
Yes.
Okay. And you've seen where there's a long list of infusion therapy supplies, medications that were ordered, and there was a problem with the order because the old medical director's name was on the paperwork.
Yes.
And you changed it to yours.
I didn't change it. They scratched it out, but I know what you're talking about. ASP Cares. We can refer to that one. It's important language.
Rest assured, we will. But there are emails showing where they're asking you to sign an authorization, and you responded, yes, done.
Yes. And you know who sent most of those? The NPs. Yes.
Yes, sir. I do understand Brent Holloway was a key player in this, but Brent Holloway is not a doctor.
No,
Brent
nurse practitioner. The emails, almost all of them arose from a nurse practitioner asking me to sign it.
But the nurse practitioner didn't need your signature to order medications. A nurse practitioner has prescriptive authority on their own. So why were you signing the authorizations to purchase the medications?
Because the nurse practitioner, I was enabling a nurse practitioner to have access to an account of supplies as this grew, as the business grew. It was all intended for a nurse practitioner to have access to supplies.
And were nurse practitioners the only people who administered IV hydration therapy at core cryotherapy?
As I found out well after the fact, it's been many years now. No, they were not.
Well, let's back up. I'm sorry, we got a little heated there. Let's back up a little bit to get the foundation laid for these documents that we understand, but the board hasn't had a chance to look at yet. All right. Besides IV hydration, what did at the time you became or began your relationship with CORE? Well, first of all, when was that approximately? What time frame?
Brent texted me somewhere around the end of June or so, 2019. And then he touched base again in July, and then things started moving as he was about to have a nurse practitioner on board. He had apparently had hired an RN, and that RN was actually finishing NP school. So he wanted to expand into testosterone replacement therapy, and that's when he initially came to me about collaborating. That was his focus, and that's in the text messages.
But you admit that you held the title medical director at Core Cryotherapy from some point in 2019 until some point in 2022, do you not?
If you're referring to a few of the applications where it had a title and it needed a title, medical director is written down there, title only.
So you never used the title medical director, never called yourself the medical director?
I know that in one brief form that some typed notes when later on I put medical director next to my name, but I know I never held a contract. I never held operational authority. I never had a key to the building. I wasn't called by the staff that ran the clinic, and I was never paid one penny.
I mean, in fact, you basically, you only went to the physical premises for what, a handful of times? How many times would you say?
At least 2 times.
So at least 2 times in a time span of over 2 years, when you held the title of medical director, you went to this practice at least 2 times.
Yes.
Did you ever go there to observe the practice that was being conducted?
I didn't have to. That wasn't my job.
Who told you that wasn't your job?
I have no contract. I had no duties. I had a collaboration agreement.
So because you did not have a contract with the clinic, it is your belief that you had no professional obligations as a physician to assume the responsibilities of the position you accepted, which was medical director.
I did not accept the medical director. That position was put on me as a title for the benefit of someone else. That was the meeting that he wanted, that we mentioned in the opening statement, that he did not want his name on the paperwork. I didn't understand at the time. I do now. And he wanted me to have the title medical director on these, and going forward, because I asked him, I said, well, you own this, you're involved with this. Why aren't you the medical director? I suppose later on, he didn't have a problem taking that title, as we'll see as we move along, as he takes on more operational roles there and out in the open.
So you're saying that Massey Headley officially taking the title of medical director was not the direct result of you giving up that title?
He was functionally the de facto medical director the entire time, and the evidence will show that.
And do you recall the email you sent to Brent Holloway where you said, you know, I'm not really the medical director here. I'm not getting paid for this. Really, within the next 3 or 4 months, you need to get another medical director. Do you recall that email?
And I think that email speaks for itself. Yes, I recall that one.
Yes, I agree with you. It absolutely does speak for itself. Okay. So what were you expecting to get out of this relationship with Core Cryotherapy, working with Dr. Massey Headley and Mr. Brent Holloway?
That's a very good question, and I won't belabor the point, but Brent Holloway worked for Medtronic. He called on us many times over the years at MEA Ridgeland. He was one of the good old boys. One day he found out, I don't do this anymore, but I used to ride motorcycles, live a little dangerously, and we even went out and rode motorcycles. And it seemed like a nice guy, and he just reached out to me one day and said, hey, I'm starting a new business. I could really use a hand. And so basically it was just out of friendship. It was out of friendship. There was no promise of any money. I took it pro bono. He didn't have any money to pay anyway. And it was said, well, as time goes on, as things move on, then perhaps maybe we'll talk about a pay arrangement. But at the time, it was all just a handshake.
So Massey Headley didn't have any role in your recruitment?
He did not. He was the silent partner, but he introduced him to me very soon into the process.
And so you did not consider that getting into a business relationship with Brent Holloway and Massey Headley might not open doors in the future for you? Because Massey Headley was a prominent physician involved in a lot of business opportunities?
You want to know the real truth? Massey Headley was a third-year superstar resident when I was an intern at a place called Methodist Medical Center in West Jackson Family Medicine. When we walked in that place in 1997 as interns, Massey Headley was the superstar. Everybody knew him. He was a moonlighting fiend. He was the man. And when I heard, oh, Massey Headley, I'd had no contact with Massey Headley. As far as his standing in the community, I knew he worked for Baptist, but as far as that goes, I was just like, oh, Massey Headley. It was basically going back in time, 20 more than 20 years to back when I was an intern, and he was that senior resident, that someone we look up to, that we wanted to be like that. We wanted to have those skills and be confident like he was.
And being involved in business with someone like Massey Headley with his reputation, that could be good for your future in medical businesses.
I didn't need that. I'm doing direct primary care. I have my own practice. I have it the way I want to. I'm my own boss, except, well, actually, I'm not. My patients are my boss. I was just helping out a friend. Otherwise, I wouldn't even have been there.
Now, you've kind of covered this, but I want to make sure the record's absolutely clear. So in your mind, what was your role as medical director supposed to be?
As collaborating physician, the only thing I was collaborating with the nurse practitioner to help expand their practice, to do testosterone replacement like I was asked, and everything else was to facilitate that relationship and grow that. Where it went, I did not know it was going to go. The business was fledgling. I wasn't given a lot of exposure on what the business was doing, other than, hey, we're going to be doing TRT here. If you'd have told me how many hydrations they were doing, I would have thought probably almost very little. But that said, I didn't have access to that information to know. I went in there to be a collaborating physician and to help an old friend out.
And so your old friend, you're talking about Brent Holloway.
Brent Holloway. Yeah, just help someone did I go eat dinner with him? No. Did I drink with him? No, I don't drink anyway. I rode motorcycles with him one day on an afternoon, and he called on us many times. He seemed like a genuinely nice guy. Unfortunately, I found out things afterwards. Obviously, that's why I'm here.
So your duties as medical director, it's your testimony that they included only collaborating from time to time with a nurse practitioner?
Objection. I asked and he answered at least 3 times.
The nurse practitioners were there, been fit in spurts over 2.5 years, only 4 of them. And that's the only agreement I ever had. I never had a contract or duties. This board has never created guidelines for a medical director of a wellness or IV hydration clinic. It has for pain management. This board is capable of writing regulations to govern medical directors, but they've chosen to do it in only one situation, pain management. So I did not have it was not my duty to do that. I had no operational access, just like I don't have operational access as a medical director of my hospice. I have a defined role, a contract, I get paid, I take care of the clinical issues that are put in front of me, and that's what I do. I did not have that with Core Cryo.
If you were going to have the title medical director put with your name, why didn't you demand access to Core Cryo to find out what was actually going on at that clinic?
I'm going to say it again, that's not my role. Just like it's not my role to do inventory for my hospice or to hire and fire or staff or do the things that are in the affidavit that I know my attorney's also going to talk about as well, the actual counts I'm being accused of.
But this board does have regulations that govern the practice of physicians such as yourself, correct?
Absolutely.
And you have an obligation to obey those regulations, don't you?
Yes.
And a physician cannot put himself in a position whereby through his acts or omissions, those rules are being violated, can he?
If you don't know, and there's fraud going on behind your back and you don't know, then how am I supposed to? Where were the red flags? Where was the things to actively tell me that you need to go and okay.
No, where were the red flags in Brent Holloway's business?
from, not in Brent Holloway's, but from what in my perspective, considering the time I was there as a collaborating physician and fits and spurts, this wasn't 2.5 years. And we'll get into the timeline of that. It's only 4 nurse practitioners. And there's some serious issues there that were caused by things going on behind the scenes without my knowledge that led to where we are today.
And you did not take steps to get the information you needed to know what was going on, did you?
If I had been, I was insulated from the process. I was basically put in a position where I was not to know. I was literally locked outside the building as far as information and flow.
Then why didn't you quit?
That's a good question. Why didn't I quit? The duties ceased on their own, the nurse practitioner. I thought I already had quit. They stopped. They were either didn't start. They started and stopped, or really, do I have is the duty to quit? That's a good question. I've thought about that, but had it been clear, because they had done such a good job hiding the operational side behind the scenes, I didn't have the information to quit. I was already, nurse practitioner comes and goes quickly before they even get approved by their own board, or we have COVID in the place, as you said with Dr. Holloway, that he said, you asked him about COVID, and one of these nurse practitioners fell under that watch, and he said we had no business for months. We got the exact quote, and then you have a third one that's a good one. We'll get in that one, and then the fourth one, everything went well because she was engaged. We got in there, got the processes down, everything happened. She was there only a short time, but we had the chart reviews. And that was over that 2.5 year span. The title you're talking about was a title on that initial credit applications that were all done in 2019 and one through another nurse practitioner in February 2020.
Were IV hydration patients at Core Cryo given a physical examination before treatment?
I didn't treat them. So if the intent was the nurse practitioner was doing it, that I was collaborating with, then that's what I would have intended.
But you were collaborating with nurse practitioners who did perform IV hydration therapy at Core, correct?
They were performing IV hydration, and you should be aware it's in the documentation.
I've been investigating this case for 4 years, sir. I know everything that's in this record. You will have the opportunity and your attorney to present evidence, but I'm asking you, did not these nurse practitioners, some of whom you were directly collaborating with, some of them performed IV hydration therapy, didn't they?
They performed it as an RN, yes. They ran, but did they document? Did they do a note? Did they do a chart review? Did they actually create an order and a chart? Were they just going in there and working as an RN? They're all RNs, aren't they?
Those are great questions, doctor. Questions a medical director should answer, such as who gave the order for the IV to be administered? Was it you? You said no.
I did not give an order, no.
Do you know whether those nurse practitioners were given orders?
They didn't create charts.
That's true. When we'll look at a couple of the charts, they're very sparse, aren't they?
They are. I didn't know about them until we got the information from this board.
Well, as medical director and as a collaborator with those nurse practitioners, didn't you review the charts?
The charts are 10% of the nurse practitioners. Those are not charts. Those are intake questionnaires. Those are not charts I don't see a nurse practitioner's writing a signature. I don't see anything there that says she evaluated them, that they needed fluids, and signed off and said, okay, this is one of my charts to be reviewed.
I agree with you 100% about everything you just said. There are no documents, no records that show that an evaluation was performed by a person with prescriptive authority, that an evaluation was done, that a medical indication was found, and that an IV was ordered by any person with prescriptive authority ever. Few occasions that these nurse practitioners mention in their affidavits. Do you agree with that?
I agree with that.
Right. And you don't think that as medical director, any of that falls under your purview?
If I did not have those duties in my collaboration agreement. My duty was to collaborate with a nurse practitioner. I know you're trying to make you're trying to make a contract or a list of duties that are just not there. Now, had I signed something in a contract that said those are my duties, I would have done them.
So your position is that because you didn't have a written contract telling you that as medical director, you were to oversee the practice of core cryotherapy, which included hormone replacement therapy, which you were more involved with, were you not?
That's what I was brought on, yes.
Right. And it also included IV hydration therapy. But if you don't have a contract that said you had any responsibility, as far as you're concerned, you're free and clear.
What I'm saying is those were not my duties. My duties was a collaboration agreement. And as far as the protocol, I did do a protocol for testosterone replacement therapy. That's the only protocol I ever authorized. And it was just a guidelines on how to do it properly.
Would you agree with me, since you agree that the records that Core Cryo kept for well, I was going to call them patients, but actually at Core they called IV hydration patients, they call them clients, right?
I did not know that at the time, but I do now, of course.
And is my understanding correct that the patients would simply come in, sometimes referred by physicians, but other times just come in off the street, pick ingredients off a menu for the IV that they wanted, and it would be administered?
I found that out after the fact, well after the Headley trial, after his consent order in May of 2022, 23.
So the client essentially decided what was going to be in the IV that they got.
That's what I'm aware of now.
All right. So were there times at Core Cryo when there was not an advanced practice registered nurse, nurse practitioner, etc., who was present to do examinations and order IVs for a specific medical indication?
That's true. Yes, there were. Did I know that at the time? I knew the nurse practitioners I was working with. Let me explain. So Miss Golston was an RN there who was hired to do IV hydration therapy. She was introduced to me as she was finishing up her NP, and they wanted to do TRT. Would you collaborate with a nurse practitioner? So the everything started rolling about, toward the end of September 2019 into October 2019. And then it built up to where, okay, she's going to be an MP. It's at the end of January 2020. They want to get moving with things. I come up with the TRT protocol, and we find out this was unknown to me, but she's a psychiatric nurse practitioner. She's disqualified by our own board. We never have the collaboration. Immediately after, he hires Kathy Graves in February 2020. He introduced her, hey, okay, this didn't work. This is our second NP. We have COVID. The place shuts down. You and it is under sworn testimony, you and Dr. Headley actually talked about that on the stands, and he said there was no activity for months. Everything went dark and quiet after that. Later, I was told by Mr. Holloway when he came back and said, hey, I've got another MP. Things didn't work out with Miss Graves. So I have another one. That was Abby Brielle Calum Richardson. Well, she was Richardson, now she's Calum. And so he introduced her to me somewhere around November 2020. Now, we're almost done. There's only 4 of them. And then I signed her. I was signing her collaboration, but I never got a copy of it. And then something happened. Wasn't getting any feedback again. And I was like, okay, I'm going after Brent and find out what's going on. Where's this collaboration agreement? And he says, oh, her husband got a job with a law firm in Hattiesburg. We don't need to add her. As we'll find out later and discuss, there was some things going on behind the scenes with her, and the reason why they never even engaged me at all with her. Then they went from February 2021 all the way to the end of July into the very 1st of August 2021 with no nurse practitioner whatsoever. And during this time frame, I'm busy in my clinic we've gotten much busier after COVID. I became the only hospice medical director. So I'm busy, not making excuses. We're busy. I'm taking care of the fires that are in front of me, like all doctors do. And then I get the call back again. Hey, Mike, I finally got a nurse practitioner that will work. Okay, we'll try this one more time. And it turned out she was good. She got there, created processes, revitalized some of the collaborations, made them better. She had the structure there, the chart views, everything was going. She was not doing a lot of work. She admits in her own sworn statement that she was only a part-time nurse practitioner, part-time. And then after that, she quit, and that was it. That was the last nurse practitioner. So that's a long time. That's 2 years, and you've got 4 short stints of nurse practitioners. Most of that time, there was no nurse practitioner. This board was told before there was a nurse practitioner, that my understanding was a nurse practitioner was here the entire time, and the process was to always get a physical examination. I know definitely based on my own experience after the fact and the timeline of the NPs, which I was able to recreate, that was not the case. At the time, I was not aware that these were the only NPs that were at core. I had no awareness that if there was other NPs, I assumed there were because it seemed like a fairly big organization. But it turns out that there was only 4 NPs the entire time. This board was told there was always NPs 3 years ago. And now we find out there was less than that time, that supposed 2.5 years, less than that time, less than half of that time, there were MPs there. So it turned, and you'll find in the very beginning, even before I got there, a year before I got there, that their process was a client model in which people could come in and get IV hydration, an aesthetic client model with no NP evaluation. And that was actually the process from the beginning. And if I had known that, there would have been a way for me to know that. Yes, I would have never entered into that, but there was no way to know that. I didn't find that out until after Dr. Headley's testimony and after I got the extra evidence from the board that my first attorney did not get.
I'm sorry, but I'd like to ask the court reporter if she could read back my last question.
Madam Court Reporter.
Oh, okay. I understand. I'll make it short.
I'm just losing my place.
Okay, go ahead. I'll try to be more succinct with my answers. I apologize.
Question. So were there times at core cryotherapy when there was not advanced practice registered nurses, nurse practitioners, etc., who was there to do examination and order IVs for specific medical evaluation?
Yes.
Thank you. Do you know whether IVs were ever administered by personnel who were not by law qualified to administer IVs?
No.
Sorry.
No.
It didn't happen, or you don't know?
During that time frame, no. During the time that I was there supposedly as medical director. But when I had my affiliation with CORE, when you say I was medical director, no, I was not aware. I did not know.
So during the time you were medical director, no EMTs or paramedics were there administering IVs?
I didn't say they weren't there. I said I did not know that was the process or that they were there. I never met them. I didn't know.
Do you know whether Core Cryo had just an RN who worked on weekends and did IV hydration therapy? Do you know whether that happened?
I don't know.
Council, we are coming up on probably an appropriate time for a lunch break. Is that all right with you, Mr. Barnes?
Yes, ma'am. This is a fine time for a break.
Okay. Mr. Mercier? Okay. All right. So we will break for lunch and return at 1 o'clock. Okay. Thank you.
If I may, while we allow Mr. Mercier and Dr. Sanders to get lunch, and Mr. Mercier, do you remember where I showed you a room that y'all can go to?
Oh.
Yeah. right down there. And then for the board members, real quick, we're going to try to line up right out here and get a group picture of the board before we go to lunch. And we can do that while they're getting their lunch and going to their room. And here, yeah.
Going right thing, either direction.
Will you get them around there so they can get their lunch?
Like that alone.
Sanders to return to the stand.
Reminder, Dr. Sanders, you are still under oath. Okay.
All right, Dr. Sanders, if you would, sorry.
Did you want to start?
Yes, thank you so much. Let's just let the record reflect that Dr. Owens will not be present for the afternoon session and will not participate in the deliberations of this matter. Thank you. You can go ahead and proceed. Thank you, Dr. Cleveland.
And proceed. All right, Dr. Sanders, if you would, take this notebook, documents, and I'm going to ask you some questions about some of them. And I'd ask you first to turn to page 4. 461.
Okay, yes.
Okay. Now, was this document is a affidavit from Kathy Howell Graves. She's one of the NPs that you collaborated with at one time, correct?
Yes, correct.
Okay. And she states in paragraph 3 that she was hired by Brent Holloway in approximately February 2020. So that would be some months after you had started a relationship with CORE. Sometime after beginning employment at CORE, Brent Holloway and I traveled to meet Dr. Michael Sanders at his medical clinic in Ridgeland, Mississippi. The purpose of the visit was for Dr. Sanders to sign our collaborative agreement. That was the only time I ever met or spoke to Dr. Sanders. Now, Dr. Sanders, to your best of your recollection, is that accurate?
Yes, in person. Yes. There was
Okay.
other communication.
Well, would that have been like in the nature of emails, or did you have
Emails.
phone conversations?
There were emails.
Okay.
Yes.
Okay. Now, in paragraph 5, Ms. Graves discusses the fact that Dr. Headley told her to contact him with questions concerning patients. She says she would occasionally discuss hydration therapy clients with him, and that Dr. Headley told her that he was available for questions that arise during the treatment of clients and patients. Correct?
That's what it states. Yes.
Right. Okay. But he was not her collaborating physician, was he?
Not on paper. No.
Okay.
Not on paper. That's my answer.
In paragraph 6, she says, Brent instructed me not to discuss any business dealings with Dr. Headley and to only discuss clinical issues with Dr. Headley. Why do you think that would be? Do you have any understanding
I
of
have
that?
no understanding.
Because, I mean, Dr. Headley was a silent partner, right? That was your understanding?
Initially, yes. Yes.
All right, the next page, paragraph 9, just confirming that Ms. Graves testified that individuals, I'm gonna try not to go too fast. Individuals receiving testosterone replacement therapy were referred to as patients, and individuals receiving hydration therapy were referred to as clients. I believe you testified that you were not aware of that at the time, but you later became aware of it.
Correct.
Paragraph 10, and I'm paraphrasing a bit, but that she says that clients that presented to court for hydration therapy were allowed to choose the ingredients they wish to have administered by looking at a menu. Is that also your recollection?
I don't know. I wasn't familiar with the menu as far as the way it's designed. It says here a menu. In terms, this is what is written here. Yes.
So you were collaborating with Ms. Graves, but you never saw the documentation or the program or the software that she used to record her meetings with patients?
She did not create charts from this, so there were no charts. So there was no way for me to know.
Well, but wouldn't the chart be whatever documentation that she actually did create?
If she did create it, yes.
Okay, she goes on to state, I administered hydration therapy to core clients to an estimated less than 30 clients per week. Sometimes asked to assist other staff members in obtaining IV access if they had difficulty obtaining access. So you have no reason to doubt that, do you?
No.
Okay. And she was an experienced nurse practitioner?
She was an older nurse practitioner. I would gather she was experienced.
Okay. Look at paragraph 11. I want your thoughts on this. Ms. Graves states, I did not oversee anyone, to include any registered nurses RN that worked at CORE. Any person that was hired to obtain and deliver IV access was referred to as a nurse, regardless of training and certification. I nor other staff members were always notified of who the nurse was, or their credentials or scope of practice. The nurse position would change personnel frequently depending on different circumstances, including availability. Now, did you know that at the time that you were involved with CORE?
No.
Just in paragraph 12, she admits that she was terminated by CORE in November 2020 and states that she was abrasive towards Brent. And I admit that I and other staff members were confrontational with him and often questioned the business practices that we believe to be unlawful or unethical. Do you recall when Ms. Graves was terminated?
No, I did not.
Okay, so according to this, Ms. Graves and some of the other personnel, other staff members, confronted Brent Holloway and questioned the business practices that they believed to be unlawful or unethical, but they never discussed those same issues with you?
No, they did not.
Even though you were medical director in name, in title, and even though you were her collaborating physician?
This was never discussed with me. No.
Okay. Do you recall how long you collaborated with Ms. Graves?
At the time, I had no idea because after COVID and they were shut down for a while, there was no more contact.
Okay, well, she was hired in February 2020, so that would have been just before COVID, correct?
Correct.
And in paragraph 12 of that affidavit, it says that she was terminated in approximately November 2020, which was at least after the emergency declarations for COVID had expired, correct, or were lifted?
No, that's not correct. The emergency did not expire until November 21st, 2021, a full year later.
2021. Right. Thanks for correcting me. You were never made aware by Brent that the staff members were questioning the business practices that he was, directing at CORE?
They didn't involve me in the business practices. It was totally quiet, silent.
Okay. But don't you agree with that from the context of this, the practices that they viewed as unlawful or unethical, you don't think that had something to do with the way they were providing services?
It's clear here that this is not lawful. This hydration therapy patients as clients, these over here are patients.
And you agree that's
I would agree. I agree. I don't agree with that practice.
Okay. All right, so the next person on page 464, Lauren Nicole Sharp. Do you remember Miss Sharp?
I never met her.
Okay. So she says that she started working in approximately March 2020. She was hired as a general manager by Brent Holloway. She says she talks about her in paragraph 4 about her interactions with Dr. Massey Hadley. The last sentence of that paragraph says, I ordered all medication for hydration therapy from an already established account. Now, you mentioned this earlier, okay? So could you please explain to the board what was an already established account? What did you understand that to mean?
There were multiple accounts, and so this is not specific, but it could have been accounts that I was asked to sign on the very initial, when we were onboarding in 2019. Could have been, but it's not clear. There were multiple accounts that were open, and not most. There were other. Dr. Headley actually opened several on his own.
But other accounts that were used to order medications and supplies, those were at some point transferred over to include your information, correct?
Well, that's this. This is the accounts we discussed this, but the accounts that we opened were on onboarding initially. That's where almost all of this was done. So I'm not sure what she's referring to there, which accounts she ordered from.
So what time frame would you say those onboarding efforts were?
September 2019, October 2019.
Okay. Now, Ms. Sharp says she never met you, never spoke to him, never saw your name on any paperwork at CORE. The only time that I heard him mention was when Kathy Graves and Brielle Richardson went to have their collaboration documents signed. So that's consistent with what you said, that you were collaborating, correct?
That's consistent, yes.
Right. You can see in paragraph 9 on the next page, she also describes the nomenclature used to describe patients and what those patients were at CORE, what sort of treatment they were there. But look at paragraph 10. I was informed by Brent that I should hire paramedics and emergency medical technicians to administer hydration therapy at CORE. Dr. Headley should be aware of their hirings as he was present during meetings when they were discussed. Beginning of the next paragraph, she says, my employment with CORE ended in approximately February 2021. So you're saying that in your time with CORE, you were never aware that Brent Holloway had instructed the general manager to hire paramedics and EMTs to administer hydration therapy?
That is correct.
All right, page 467. This is from Abby Brielle Calum. Again, I'm not sure how to pronounce her last name. Is this the same person as Abby Richardson?
Yes, it is.
Okay. So in paragraph 3, she says she began working in approximately November 2020, hired by Brent Holloway. That was during your time at CORE, correct?
Correct, yes.
Okay. On my first day at CORE, I met Dr. Michael Sanders at his medical clinic in Ridgeland, Mississippi. The purpose of the visit was for Dr. Sanders to meet me and sign our collaboration agreement. Okay. When you met with her on that day, did you discuss anything about the type of practice that she would be conducting at CORE?
Other than collaboration, we were meeting for collaboration. As far as what conditions at CORE, no.
Right. What I apologize, poor question. What I was trying to ask was, did you not discuss with her the types of treatments that she would be conducting in accordance with this collaborative agreement that you had with her?
It was testosterone replacement. That was the point of and in fact, she even says that.
So nothing about IV hydration therapy.
Nothing about IV hydration.
Okay. In paragraph 5, again, she talks about Dr. Headley again, and toward the middle of that paragraph, she states that I was instructed by Dr. Headley to contact him with any questions regarding patients. Although we did not discuss hydration therapy clients, I was under the impression that Dr. Headley was available for questions that arise during the treatment of clients. But she didn't discuss any of the therapies she was providing with you or call you with any questions
No,
as her
she didn't. No, she
collaborative
didn't.
physician?
She did not.
Okay, again, in paragraph 6, she confirms the patient-client dichotomy there. Paragraph 8, I was informed by Brent upon hiring that clients that presented to CORE for hydration therapy were not examined by any provider at the clinic. I administered hydration therapy to CORE clients to approximately 3 or 4 patients per week in accordance with CORE procedures. So this nurse practitioner was informed by Brent that examinations were not conducted, but you as the medical director, that was never brought up to you. You never learned that.
That was something I never learned.
Paragraph 10. I did not oversee any registered nurses that worked at CORE. To my knowledge, ARN worked on weekends without any supervision. So if that occurred, you were not aware of it.
I was not aware.
But you agree now, based on your knowledge at this point, that an RN would not be qualified to order. They'd be qualified to administer an IV, but they wouldn't be qualified to order an IV. Do you agree with that?
I agree with that.
All right, next page, which is 469, we've got Carrie Golston. Now, let me just ask you this without diving into this. Now, as I understand it, based on what she says, Carrie Golston started working at CORE just as an RN.
Correct.
Okay.
Her state.
But then at some point she became a PMHNP-BC. That is a
Psychiatric.
psychiatric
Mental health. Yes.
Right. Mental health. All right. Paragraph 6. Ms. Golson says, while working at CORE, Michael Sanders, MD, was the medical director, although I had very limited contact with Dr. Sanders.
She would likely understand. Well, I'll wait.
Okay.
I'll wait for your question.
All right. Paragraph 7. I was hired as an RN at CORE for purposes of administering IV therapy. All CORE customers were referred to as clients. Okay. Did you have a collaborative relationship with Ms. Golston?
Actually, no, it never was approved.
Okay. She says, I do not know who ordered the medical supplies that were used in IV therapy. Paragraph 10. I would prepare the client's requested IV solution for administration and begin the administration. IV administrations were prepared and administered in accordance with standing orders issued by the clinic, provided by Brent, who stated the orders were issued by Dr. Sanders. Now, do you agree with that statement?
I disagree with them.
Okay, we'll explain what you disagree with.
I never issued standing orders. I never issued an IV protocol. Brent, this is hearsay. Brent told her I was unaware of this.
Well, that's why I was giving you the chance to explain. Again, in paragraph 11, she says, working as an RN, I had little to no interaction with Dr. Sanders, meeting him only once. I met Dr. Sanders at his office to discuss me possibly collaborating with him for the purpose of performing testosterone replacement therapy. She goes on to say that never worked out when because she was not qualified.
Yes.
As she was a specialist in mental health.
Right. Correct.
Okay. Okay, let's move to page 487. See, these documents in between pertain to Ms. Pulliam, but I'd like to cover her affidavit first. So do you recall working with Ms. Pulliam?
Yes, very well.
Okay. Paragraph 4, on July 29th, Brent Holloway and I traveled to Dr. Sanders' clinic, Face Value Health, to meet him and have him sign our collaborating agreement for the HRT clinic. Dr. Sanders and I had at least one meeting at court during my employment. During the meeting, we discussed the review of patients receiving treatment for hormone replacement therapy, diagnostic and testosterone treatment protocol, and collaborative forms. I do not recall Dr. Sanders ever referring any patients to CORE for the purpose of receiving hormone replacement therapy or IV therapy. My interaction with Dr. Sanders was limited to the signing of our collaborating agreement, the aforementioned meetings, and monthly chart reviews that took place electronically. So Ms. Pulliam, all she did was hormone replacement therapy. Is that right?
In fact, that's in line. Yes, that's what she did.
And it looks like, and I don't want to misrepresent this, but it looks like you had detailed discussions with her about that. Or I say detailed, but at least some extensive conversations. You had multiple meetings with her to talk about the collaboration.
Yes, correct.
All right. I really like to get your view of paragraphs 9, 10, and 11. This is on page 489. Ms. Pulliam says, I began seeing HRT, that's hormone replacement therapy, correct?
Yes, correct.
HRT patients at CORE on September 14th, 2021. On this day, the Mississippi Board of Medical Licensure, MSBML, and Board of Nursing, BON, made an impromptu visit at CORE, where I presented signed protocols and chart audit forms to the boards. After the boards began questioning the IV therapy practice, I inquired of the boards of the alleged business model discussed with Brent. I was previously informed by Brent that CORE had received approval from the MSBML to operate this business model. I specifically recall that I inquired about the business model, which allowed CORE to administer IVs without an ordering provider. Brent assured me that he had contact with the MSBML and had the board's approval to proceed with this business model. Following the board's visit on September 14th, I asked for written verification of such arrangement from the MSBML. Brent alleged that he could not find any written material from the MSBML to validate approval for the business model. He said he asked his ex-wife Gretchen to no avail. Insisted that the arrangement was approved despite the lack of paperwork to support this claim. So this was made known to a nurse practitioner working there, Ms. Pulliam, by Brent, who had discussions with him, who had concerns, raised concerns to him, and he told her that this board had approved the business model. Do you know anything about that?
I know nothing about it.
Okay, so you never had any sort of discussions with Brent about the approval of the business model?
No, I did not. Wait, let me preface that. I did ask him after the fact. I want to be in January and texting after she left and a lot of discussion had happened. I asked him point blank that did he ever, I don't want to paraphrase this, but we have the text, but I'll paraphrase. He basically said he denied that he said everything was good. He was getting approval. He said that in many areas, but no, at this time, no.
But you didn't ask him till after the board began the investigation.
I was unaware of it.
Right, but you didn't ask before.
I didn't ask before because I didn't know about it. It was unknown to me.
All right, well, let's get into a little detail here. We get in paragraph 12 about ordering of supplies. The manager of CORE, Brooke, ordered the medical supplies that were used in IV therapy. During a visit by investigative staff of the MSBML on September 14th, 2021, Brooke stated that the IV therapy supplies were ordered under the authority of Dr. Headley. During the board's visit, Brooke suggested going forward, the IV supplies be ordered under my provider number, that is Ms. Pulliam's. However, I was not comfortable with this arrangement and would not allow it. During my brief employment at court, it was my understanding that Dr. Headley was the only physician that Brooke would contact when ordering supplies, including but not limited to IV hydration supplies and vitamins. Now, do you agree with that description of how IV hydration supplies and vitamins were ordered?
I have no knowledge of it. I don't have a reason to disagree with what she's saying or disbelieve what she's saying.
We've covered a lot of this, so excuse me while
No, take your time.
I go through my notes. So is it your understanding that no IV hydration medications, vitamins, supplies were ordered using your credentials?
Can you rephrase that question? Let me.
I'll
yes,
rephrase, but I
retry.
probably can't do it exactly.
Okay.
Is it your position that your credentials were never used at CORE to order IV hydration medications or supplies?
At the time, I was unaware of that I had never personally authorized them to order any medications. As simple as that. I had never said order this many bags of fluid, or that was not, I did not communicate operationally with the staff there, with the people that were managing the operation, and say, yes, go ahead and order this many for these client patients. I was not aware of the client model, and I was certainly not telling them what to order and how much to order.
Hey, sir, did you ever take steps to learn whether anything had been ordered in your name and what was ordered?
Well, I was unaware of the process. The credit, I'm not going to deny that these, and after the fact that these credit applications were used, it's well documented here. There's no reason to deny that. This is that they did use my credentials to order IV supplies. They did that, yes.
And in fact, you signed documentation that allowed them to use your credentials to order supplies, didn't you?
Yes, all on the front end in the context of entering into a collaboration agreement.
Okay, if you could flip all the way back to page 1. Apologize, I know it's a long thing, but I just, you mentioned, you said that that as far as you knew, charts were not created at CORE for IV hydration clients. And so I wanted to ask you to take a look at pages 1, 2, 3, 4, and 5 and tell me if you've ever seen this documentation or this type of documentation before.
I did not see this documentation.
Okay.
This time frame.
See, this was down the bottom of the first page. You see it's dated April 26, 21.
Yes.
Okay. Flip the next page. You got a little check the box family medical history. The next page, there's some questions, basic questions. Do you exercise? The bottom, what is your main use of IV therapy? Circle all that apply. And this patient circled health and wellness and rehydration. We're on the same page?
Yes.
Literally? Okay. And you turn to the next page, page 4, and it says purchase history. And I want to ask if your interpretation of this document is the same as mine. It appears to me that, reading from the bottom up, that initially this patient on April 26, 2021, purchased a bag of Myers cocktail by IV with a glutathione, if I'm pronouncing it correctly.
That's correct.
Add-on, right? And then she came back and did the same on September 13th, 2021, correct?
That's what it says here. Yes.
Right. And so if you look at the next page, again, it's another document related to that same patient. And see in the top right-hand corner, it says 9/13/2021, Myers cocktail IV bag, PRN. Bottom right corner, Myers cocktail IV with glutathione and add-on administered in patient's right AC via 22 gauge angiocatheter wide open rate via 15, and I don't know what GTTS is, at wide open rate, patient tolerated well, no adverse reactions. Okay, that's the end of the records that CORE provided us about this patient.
Are you saying these are ones I should have been, that should have been part of the
Well,
collaboration?
I'm asking
Is that what you're
why you were not aware or familiar with the documentation they were using.
These are not nurse practitioner documents. This is not a written note or a SOAP note or a history and physical authored and written by a nurse practitioner. This is just onboarding questionnaires they used. These were not shared with me, and there was no reason for me to review them in a standard collaboration agreement.
But you agree this doesn't satisfy the requirements for a medical chart.
I agree, yes, with you.
And also to say there's nothing in that documentation to indicate that a physical examination was performed and that a proper medical indication was reported.
There's nothing here. I agree with you.
All right, starting on page 6 and going to page 27, there's this long document. The heading is Core Cryotherapy and Wellness Protocols. And it goes all the way to page 27. And at the bottom of that page, it's dated 7/12/22. I have reviewed these protocols and agree with them, Massey Headley, MD.
Yes.
Okay, so you were no longer the medical director at that point.
That's when he claimed he was the medical director for 1 month, in that month, yes.
Okay. Were there ever any similar documentation, wellness and cryotherapy and wellness protocols issued for use at CORE during the time you were the medical director?
No, there was not.
So you never gave any standing orders permitting the administration of IV hydration therapy?
No.
All right, now this gets a little bit tricky because some of these are really difficult to read. But if you turn to page 49, and I understand that your attorney's probably going to go through more of these, and so I'm not going to try to cover every document in here. I'm just going to try to ask you about a few. I'm looking at page 49 and 50. Starting at the bottom, it appears to be a text message from Brent Holloway. Says the FDA states that compounding does not include mixing, reconstituting, or similar acts that are performed in accordance with the directions contained, Ms. Court Reporter, in approved labeling provided by the product's manufacturer and other manufacturer directions consistent with that labeling.
Okay. This was in response to that one meeting that Priscilla alluded to at CORE, where, and once again, this is a month after the board and made the visits to both their office and then to my office. And so they were having a general discussion across the board. And they were talking about rules about compounding medicines. So Brent was sharing this with it. Actually, I think he might even texted it, looking at the time, 7:25 PM. It was actually at that very meeting. He was texting that.
Okay. And on the top of the next page, this appears to be a response from you, and I want to make sure that's correct. Sounds like that answers the question. I'm not impressed with these investigators that the board is sending out. So the board passed a resolution that allows them to take the license of any physician accused of spreading COVID-19 vaccine misinformation, and yet they send out investigators that do nothing but spread misinformation. What misinformation are you saying that the board's investigators were spreading?
It's been a while, so I can't determine exactly what that is, but I can tell you what motivated this text. And it would have, what happened on September 14th, the board, this is probably not the best setting to talk about it, the way the whole thing went down, the way the board members, 3 of them came in, and so I won't over-explain that, but it was a very traumatic experience where flashing badges, clear out this office. I can do this to you. It was, I was threatened with license suspension and revocation right there on the spot before anything was ever, any chart was there. So I didn't have a good taste in my mouth about the board. And I was also, my background, I won't go too deeply in that, but I had studied about, it was a condition called antibody-dependent enhancement with the COVID-19 vaccines. So I had already had experience seeing some information and serving on the Institutional Review Board for research and seeing a lot of things being corners cut with the way that was administered. So that was motivated a little bit of anger. It's certainly in hindsight, it's not intended as an affront to our board members here who take their time and serve this community.
But going on, Brent Holloway responds, it is asinine what they are doing. I understand protecting the public, but this is likely, I assume that means like the Gestapo. It really is absurd how they work. And your response was, agree 100%. Did I read that correctly?
Yeah, that's correct. But it's not that what we're saying is both of us, we had different experiences. And at this point, I have no reason to confront Brent. That I still am not aware of so I'm just agreeing with him and texting because we both had a bad experience.
Yes, sir. Well, if you would, flip back to page 49 where Brent has this quote about compounding. Did you ever look at that definition yourself?
I didn't. I did not.
Right. Well, Brent wasn't a doctor, but you were.
No, I wasn't involved in that side of the business.
Have you ever become aware? Well, all right. You were the doctor in this relationship. Brent was a businessman of some type. Did you ever become aware that that's only part of that definition?
Once again, it was not part of what I was doing. I wasn't testing this out and studying this because it was a general meeting with many people talking about different topics. I was simply there, invited into the boardroom basically one time to have a discussion with other people there who knew the entire business. I didn't know that. He was sharing this with the whole group and he was texting this.
All right. Well, let me get to let me skip forward and get to a document that I think is related to this on page 143. I'm not sure if this is around the same time frame, but perhaps you can explain it to me.
This is it.
It is relevant.
No, this is the document I'd alluded to.
Okay, so was this the meeting you were talking about when you were discussing various techniques? Okay, at the top of the page, it says Core Cryotherapy Quality Assurance Quarterly Meeting. That's required by your collaboration with nurse practitioners, correct?
It is. This was more than just that, though. It was me taking notes on the entire proceeding.
Okay. Attending, 1, Michael Sanders, MD, Medical Director. 2, Brent Holloway, president. 3, Brooke Tackett, manager. 4, Priscilla Pulliam, NP. And if you drop down to number 4, discussion of potential, oh, by the way, do you know who produced this?
I actually
minutes?
pulled out a computer with Google Docs. Yeah, I just typed it freehanded.
Okay.
I have a habit of any meeting I go to, whether it's St. Dominic, just open it up and just type free type.
Okay, so you actually produced this document.
Yes.
Okay, number 4, discussion, again, this is in October of 2021. Discussion of potential changes with the way Mississippi regulates health and wellness clinics. Anticipating potential changes, including a potential requirement that all prospective patients be formally seen by a provider.
I was free texting what was being discussed there.
Right.
And
Well, was that your understanding in October of 2021 that an examination by a provider was not already required by the state regulations? Excuse me.
I typed that out. I did not fully understand what the process was, because I've mentioned this before, that Mr. Holloway, as he has said in many different areas in these affidavits, had always claimed he had some type of approval from the board for whatever he was doing, his process, which I was not operationally involved in. I had the collaboration agreement. That's what I took. That's what I was here for, the collaboration with the nurse practitioner who could order fluids or anything that she needed to do as long as she did the evaluations. So this was basically a hearsay, me typing it out hearsay. It's not something that I consciously said, okay, I'm taking ownership or agreeing with it. In fact, we go later on and I ask him again because he's claiming that he has some type of special, same with, well, you've got it in multiple areas.
Right. Okay. Well, going on, paragraph 5, acknowledgement that core cryotherapy does not compound medications and therefore does not require a hood. We compared processes with those in a typical hospital or outpatient setting. Common medications that are mixed with IV fluids do not require a hood in those other settings. We do want clarification on how many different vitamins/agents can be injected in an IV bag of fluid. Okay, did you ever learn what the answer to that question was and has been?
This was hearsay. I was typing out what the discussion as was happening.
Well, the medical professionals involved in this meeting were you, MD, medical director, and Priscilla Pulliam, a nurse practitioner, and the other people were not healthcare personnel, correct?
That's correct.
So who was discussing it?
Brooke and Brent, that I recall.
Okay.
It was a free discussion. They knew that business much better than I did because they were involved in it. They created the whole process.
So you relied on the business people, the administrators involved in core cryotherapy for your understanding of medical requirements or legal requirements for medical practice?
Once again, that was not my duty. This was not my duty I did in this area. This was never this. I didn't own this process. I was taking this by hearsay, and I didn't have a reason at that point to push back on what Brent was saying, because Brent, that was his ownership, and Massey Headley was very much involved with this. So that I always felt like they owned that process.
Okay. Well, even if as a physician, that didn't sound right to you. You don't, do you not feel that you had any sort of an obligation to question or push back with Brent about any of these topics?
Well, at that point, I didn't even know how many patients they were seeing. I was like you, probably quite surprised to see the volume of patients and the money that they were charging. None of that was, I had no understanding of any of that. Once again, I was there as a collaborating physician for a nurse practitioner.
Okay. So paragraph 7, Dr. Sanders to be invited to IV groups to begin having discussions with others about regulations. Can you explain that statement to me?
in the after this aftermath of the investigation, and now all of a sudden they're suddenly worried about where they stand with this board and regulations. They wanted to put basically an olive branch out to me to say, hey, we want to invite you into the club to figure this out. So you learn about regulations. So, okay, that's at the time, that sounds like a reasonable idea to learn about the regulations if my role here was finally going to grow somewhat.
Okay, so after the board began its investigation, and after this meeting, basically, I don't know if you were directed or instructed or invited to IV groups to begin discussing the regulations governing that medical practice. And before this point, you had not had any of those discussions.
No, we did not.
If you would turn to page 55 and 56, I also need you to explain an exchange between you and Mr. Holloway. And this is part of a longer thread. So if you feel like, you need to refer to any of the other, communications, please do so. But I'm starting on page 55, and I can barely make this out, but I believe this looks like a text to me.
It is
11022 238, and I can't make out the seconds, but apparently it was January 10th of 2022. Does that sound right to you?
That's right. That's correct.
Okay. So am I right that this first text in black is from you?
Yes, correct.
Okay. All right. Also, have we determined if every infusion will need a provider order? Did we ever answer that issue? Brent, it will not once the pharmacies we order from get their paperwork back into the state. Everything is supposed to be back to normal by January 22nd, per my last email from Olympia. Okay. Then you responded, I figured the board would have clarified that issue since that was one of the reasons they were investigating. I think we need to go the extra mile and make certain, especially if they ultimately fall on my licensure. When was Priscilla's last day? Now, the comment about Priscilla is separate from the pharmacy issue, right? That was Priscilla was leaving and y'all were making arrangements. Okay, so what was this discussion about the pharmacy about? What exact issue were you discussing with Brent?
This is me basically becoming more aware of what they're doing on the other side of their business, the one that I had no operational control over and was locked out of. And my concern was more general in terms of my licensure, was that, okay, my name is affiliated with this business. And if you're, if you're not sure what you're doing is correct, or there's questions, the last thing I need to have as a collaborating physician is to have the board suddenly get caught up in your mess, be in the wrong place at the wrong time. That's what it means. It's actually me trying to reach out and get clarification and make sure they're not just, they're following the rules.
Okay, well, let's drop down. Again, in 2022 is when you began exploring that, correct?
Yes.
Okay, down toward the bottom of the page from Brent, I will check, I believe it's a typo, and confirm. They never gave us any guidance. I have a call. I think that's supposed to say in to them, and I'll call again tomorrow. Do you agree that with the way I interpreted that?
That's correct. Yes.
Okay. And then you responded, thank you. That will be critical for us moving forward. I'm too busy in my own office and with my hospice to handle all orders personally. Now, were you talking about orders at the clinic to order a medication, or were you talking about ordering medications and supplies from a pharmacy?
No, I'm talking about moving forward to be the one writing orders for all that that you're going to have a doctor's order for every single fluid. That I'm saying that if this is what you expect me to step in and do, I'm not doing that. It's not about ordering medications from a pharmacy. It's
Well,
not.
what type of orders are you referring to? if you're
It's
not
the, it's
pharmacy
the
orders?
very reason we're here today. It's because these things were administered without a physician's or NP's order. Fluids were
Okay.
administered. That's that's what I'm
So
referring
this has nothing to do with the 403 B
No, it
outsourcer?
does not. It does
Okay.
not.
Well, great. I'm glad. Thank you for explaining that because I was confused, to be honest. Okay. And on the next page, you go on to say, especially when you consider my status with Core Cryo as unpaid, non-owning medical director. But at this point, that is my best defense if the board revisits September 2021. Their visit and attempt to harass me was motivated by their desire to attack Core Cryo. Then there's another text directly from you. And if Massey can't help at all with any medical situation, then we have a real problem. Brent, thank you, Dr. Sanders. I will get everything taken care of this week. I'm talking with the attorney as well. She will be able to shed some additional light on the situation. I'll let you know what she says. I will work on a way for us to start paying you something as well. Business is starting to pick up, so I'm very helpful.
Hopeful.
Did Brent ever take care of any of the issues you raised?
No.
And what did you mean by, and if Massey can't help with any medical situation, then we have a real problem?
I'm referring back to this new requirement that, once again, that you want orders and now you want me to step in and be the ordering physician for every situation. At this point, we have no nurse, there is no nurse practitioner. And we also have this issue is that, hey, is this model that you're saying has been approved by the board? Are we square with that? So that's what it's referring to. And Massey Headley being an owner and a medical director, that's his involvement. So.
Okay, well, thank you again. I was confused because the word order can be used a lot of different ways. But here it was someone at Core finally recognized that orders were required for IV hydration therapy to be carried out.
Yes, that's correct.
But that wasn't until January of 2022.
Correct.
Okay, on page 69, I think there's another communication that you have referred to. So I just want to give you a chance to for us to talk about that. This is on the bottom of the page, 69. These appear to be emails. These were printed from your computer, is that right?
Right. I
Michael
provided
Sanders.
yes, I provided the text messages. I provided all these emails to an investigative hearing at the board in October 2022.
Well, thanks for confirming. I hadn't made that clear, so thank you for clearing that up. This is an email from you to Brent on May 10th of 2022, correct?
Correct.
Brent, I am moving into a supervisory capacity with a nurse practitioner. In addition, my hospice wants me to serve as collaborating physician over the nurse practitioner since I've moved into the primary role of medical director. When considering their insurance policies, I'm in a predicament because it will not allow me to supervise more than 2 locations. All right, so your primary practice was changing, and the insurance company was saying you can't do 3.
Well, honestly, I don't recall if I was trying to gracefully get out of this thing. We had no nurse practitioner for 5 months, and I got approached by somebody whom I knew and respected, and I thought this is the time to. I remembered this whole thing. He keeps showing up after several months, and I just wanted to be totally free and clear. Graceful way to exit.
Okay, but what you said in the email to Brent, I reported it accurately. What you said.
Yes.
Okay. Going on right now, you do not have a nurse practitioner that I'm supervising. Also, I have become increasingly concerned about the current liability climate in regards to the Board of Medical Licensure. Although I'm listed as the medical director, I'm really not serving in that capacity since we can go many months and I hear nothing about the clinic and I'm not really well versed on what's going on at the clinic other than infusions being provided. Finally, I'm receiving no stipend, no ownership interest, etc. I think now is the time to start transitioning to another medical director. I think Dr. Headley should take over that role. I do want to make it clear that my decision is final, and at least in the next 3 to 4 months. My name needs to be removed as medical director of Core Cryo. So I read that accurately, did I not?
Yes.
Okay, if you were not the medical director at that time, why do you tell Brent that Dr. Headley needs to take over that role?
I knew by then my name was being used as medical director. The name was being used, but I had no control as maybe a medical director in another system might have. I just didn't have it. So I wanted to make sure that anything that they had that said I was the medical director, anything from anything on a piece of paper or that could still be there, I want it off. I was giving him no outs.
All right, would you look at page 91? And I think that this thread goes back to, it may go back further, but it goes at least back to MSB number 93.
Okay.
Now, I just want to ask if I'm understanding this correct. Okay, on 93, it looks like it's an email from someone named Michelle Nall, May 14th, 2020, to Kathy Grace. That's one of the APRN. Right?
Yes.
Subject glutamine. What is glutamine?
It's one of the many substances that they put in infusions. People want it for like antioxidants and.
Okay. It says, hey, Miss Kathy, we're in the process of reordering your glutamine. Here is one form we are needing from you guys. I have pre-filled out the CC info, but there's a little bit of info that I didn't have in my files at home for you guys. If you could please send that back to me and we'll get the glutamine out the door for you. Thank you again. I apologize for the confusion on the order. Please let me know if there's anything else we can help with. Okay, I'm not going to read all the extra stuff, but are you familiar with this email?
Yes, I am.
Okay. So this had something to do with the paperwork at this particular pharmacy was not in line for Core to reorder glutamine. Glutamine. Is that right?
That's correct.
Okay. And if you go to the page 92, there's what appears to be an email from Kathy Graves to you. Well, first of all, there's an email that says, hey, all, I forwarded this to Dr. Sanders so he can complete it. Dr. Sanders, would you please complete this attachment and return? This is glutamine, which we'll be adding to our new IV menu. Thanks so much, everyone. Okay, so Kathy Graves was sending you some type of document so you could complete it, correct?
That's correct.
Okay. You never produced the attachments with these emails. Do you remember what that attachment was?
I don't, with the Doc RX, I never saw it. Don't recall that one.
Okay, going back another page to 91, down at the bottom, it looks like an email from you, info at face value. That's you, correct?
That's me, correct.
Got it, signed, Dr. Mike. I read that correctly?
That's correct.
Okay, now if you continue backwards and you'll get to, I'm sorry, I apologize. Is there any more of that thread that's relevant here that
That's all I'm aware of.
Okay. All right, let's look at page 95 and 96. And again, I think this email thread actually begins on page 94. And if you look on page 97, it has a list of attachments of what was attached to this email. But none of the attachments were produced. So
No,
look at-
no, actually, these were not attachments. This is the way when you're harvesting Gmails, these are actually every single email. And there's attachments and all, but it's just the way, it's hard to explain. It took me a while to figure out how to get, when the board wanted this information, I wanted to make sure I gave them accurate information. So this was something that was a leftover from it.
okay. Well, on the bottom of page
.ml,
96.
see, .eml, see.
Oh, I'm sorry. Sorry for interrupting you. On the bottom of page 96, it's an email from Brent Holloway, February 17th, 2020. I know we have a new contact for ordering. Please send me her information and I will pass on to the new NP. I'm setting up her email today. We are completely out of a few products and need to order ASAP. I'm not sure how the Toradol and Zofran come, but Dr. Headley asked that we order 10 doses of each. And then there's a list. We're going to cover it in the next email above, so I won't go through it here. But if everybody's looking at page 96, you can see the list of supplies. Am I correct that all of those are infusion medications or supplies?
They appear to be, yes.
Okay. So going up, the next email, this appears to be an email that was forwarded from someone. I can't tell, and if you can tell, great. But there's the renewed information about a new contact for ordering, and it says, but then there's a list of the documents, and I want to make sure I understand what these are. 3 vials of vitamin C, 2 vials of the Myers cocktail. If you have something other than the 2 vial mix, that would be great. 3 vials glutathione, 2 zinc, Toradol, Zofran, 3 vials NAD+, 2 vials CoQ10, 2 vials B complex, 2 vials magnesium, 1 vial MIC. What's MIC?
I'm not sure.
Excuse me. 3 vials B12. Now that was, I read the list correctly, didn't I?
Yes.
Okay. Now, if you go back to page 95, it looks like, again, a thread between you and Brent, perhaps others. It's from you. What Brent was asking you or saying to you is not shown here. But your response is, thanks, I'll get it signed and back to you by the end of the day, Dr. Mike. Do you remember what that was?
This appears to be tied in with the, not sure about that, no. But there was several of these, it's the way the Gmail does that it started with, well, that was back in May. I'm not sure about that, no. I don't think that was March 25th.
Okay, well, if you look at page 92, starting a little bit about a third of the way down the page, Kathy Graves. I think, well, I already read this. I forwarded this to Dr. Sanders so he complete it. Dr. Sanders, would you mind complete this attachment and return? This is for glutamine, which we will be adding to our new IV menu. Thanks so much, everyone. And that is the message that you responded eventually to, got it signed, correct?
Okay, that's May 14th, and this is, that was March 25th. There's a lot of mixed in emails, so it's hard to say.
Well, I understand, but on the emails that had that list of supplies that were being reordered.
Oh, the thanks, I'll get it signed and back to you by the end of the day. That's the collaboration agreement.
Collaboration agreement,
Yes,
okay.
that's part of the thread.
Well, in the February 2020 emails about ordering the revised core order, you were copied on those emails, were you not?
Copied, yes.
Okay. But so February 18th of 2020, you were not without any knowledge of what sort of supplies were being ordered by Core. You had seen these emails and saw a list of the infusion supplies. Is that right?
That's correct.
All right, let's look at page 103. Sorry, I got the wrong page number. Excuse me. Look at 148. Okay, on the left page, on page 148, it says financial documentation.
Mhm.
These are documents you produced to us, correct?
I don't recall if I produced them, but I know that they're here.
Well, look at 148, financial documentation.
Yes, I'm looking at that. Yes.
Is that not, you produced, didn't you produce 1, 2, and 3? The correspondence?
I produced, I know I produced the emails and the text messages that we just went through. Yes, I produced those. But
Okay,
as far as this, I'm not aware that I produced these to the board.
page 149. Could you please explain to the board what that document is and what its purpose was?
This was right initially, right on the very initial part of the collaboration when Brent approached me and said that we need to, get some accounts going for supplies. So that's Medline.
Okay. The top of the page, healthcare practitioner authorization form. I authorize the use of my state medical license or DEA license by Medline for the account and facility address specified below for the purpose of purchasing prescription drugs and/or prescription devices. I read that correctly, did I not?
You did, yes.
Okay, and down at the bottom, 15970, that's your Mississippi medical license number, isn't it?
That's correct.
And it's a signature of licensee. Is that your signature?
That's my signature, yes.
And 9/19 of 19, is that correct?
That's correct.
And I don't know, the print, is that also your handwriting?
Yes.
Okay. Okay, so moving on to the next page. ASP Cares. What is ASP Cares?
It's a compounded office use medication company.
Okay.
It's a pharmaceutical.
And at the top of that page, it lists some conditions that the practitioner agrees to purchase compounded medications under the following guidelines. Right?
Yes.
And they set out
Yes.
some conditions. On the next heading, in order to ensure that all orders received by ASP Cares are pursuant to a valid practitioner-patient relationship, we require that our practitioners agree that the following elements are satisfied prior to sending an order. The existence of these elements is an indication that a legitimate practitioner-patient relationship has been established. 1, the patient has a medical need, a medical history has been taken, a physical examination has been performed. 2, a logical connection exists between the medical need, the medical history, the physical examination, and the medication ordered. 3, these medications are provided for administration to the patient. All medications ordered for office use will come clearly marked office use only, not for resale. Now, I believe you referred to this form earlier where you said they crossed out the earlier information, which I guess, what was that?
Winston Capel.
Dr. Capel, okay, and that they filled in your license number 15970, correct?
Right, that's my
Your NPI number 103312868, correct?
one. Yes.
Your DEA number, BS 600, or maybe that's a 5, BS 6008216. That's your DEA number, correct?
Yes.
And is that your signature?
Yes. Yes.
Look back at the top of that page on those conditions.
Mhm.
Compounded medication may only be administered to the patient and may not be sold to the patient or to any other person or entity. 2, the practitioner shall record the lot number and beyond use date of any compounded medication administered to the patient on the patient's chart, medication order, or medication administration record in order to facilitate any recalls associated with the compounded medication. Was number 2 ever done at CORE?
I don't know that. Don't know the answer to your question.
But your credentials are being used to order medication under this agreement.
Yes.
Okay. Page 151. There's several pages in a row,
We'll come back to
and
that.
I'm sure not going to dive through all of this, but I just want to confirm. So Axia Pharmaceuticals controls substances agreement. So is Axia another pharmacy that CORE used to order medications and supplies?
Yes.
All right. So authorized person, purchasing agent, is that your handwriting?
Yes, it is.
And what is your title?
It has a title on here, medical director.
And
Others
that's in
don't.
your handwriting too.
That's my handwriting. It has a title. It needs a title for the account. So
Okay.
it's medical director and the title there.
Okay. Agent signature, I can't make that out. Do you know who that signature is?
Agents, that's my signature.
Oh, okay. This is what, 1/29/2020, and then that's your signature at the bottom of the page, correct?
Yes, correct.
Okay. Flip over to page 152. There's a lot of text there, but I don't see any of the boxes filled in or checked. So let's move on to page 153. Again, under the company official section, the signature block, that's your name, your signature, your title of medical director is included, and it's January 29th of 2020. Is that correct?
That's correct.
All right. Page 154. I make these representations for the purpose of obtaining controlled substances. I certify all the information I've provided is true, complete, and correct, and that the business named above operates in compliance with all applicable federal and state regulations. I further certify I am authorized to make these representations on behalf of the organization named above. Again, it's signed by you, your name, date, and your title as medical director.
That's my signature.
Okay.
One clarification.
Yes, sir.
Purpose of obtaining controlled substances, and you flip back over, there's a check. This practice does not use controlled substances, but is aware of the policies herein. Just wanted to clarify that.
Okay. This practice did use testosterone, did it not?
It only through prescriptions that were obtained at the pharmacy.
Okay. But are you aware that testosterone under Mississippi law is a controlled substance?
It is, but they were not obtained outside of a pharmacy with the doctor's order, with the doctor's prescription.
Okay. Then page 155, again, then there's a statement about charges and payment. And there's your signature again, your name, medical director. But is that your credit card information?
No, it's not.
Okay, whose is that?
That's CORE's.
Okay. Okay, when I was preparing, I was not sure that this was relevant to your time at CORE. But if you would turn to page 209. Again, now these documents, again, there are patient names all over these, so we need to be very careful not to mention those. and they're sideways. I apologize. That's the way they came. So on page 209, it says daily appointment list 5/02/2022. So at that point, you were still, at least in name, the medical director at CORE, correct?
That's at least in name, correct.
Okay. And so the first one is for May 2nd. Flip over, there's one for May 3rd, May 4th, and so on. What I want to ask you is about the employee column. Well, first of all, I'll talk about, look at the service. Mega metabolism, IV bag, whole body cryo single. So that's the first one is an infusion therapy, correct?
First one looks like, yes, must, yes. that's
And
right.
a couple down, glutathione add-on. That's also refers to infusion therapy, right?
Correct.
All right. Going down, there's a little bit like there's another reference to a Myers cocktail IV bag. Lipo B12 is mentioned on that page. Those all are references to infusion therapy, right?
That is what they appear to be. Yes.
Okay. But so you were the medical director, but you never saw these daily appointment lists.
I never saw these appointment lists, and these are listed from July 1st, 2022.
May 2nd, 2022.
Pretty sure. May 2nd. May 2nd.
Is that, am I not
Okay.
correct?
Okay. I see they're printed out, but no, I did not see these appointment lists.
Yeah, they were printed out on July.
Yeah. Okay.
1st.
You're
I
correct.
apologize.
These are May 2nd, May 5th, and no, I did not see these.
And you never asked to see them, did you?
I didn't know they were there. I'm honestly was shocked they were seeing this many patients.
And you didn't think it was part of your job?
No.
Okay, well, let me ask you about the employee column. Okay, most of these are names, clearly, but PRN, what does that reference on the chart? What does that mean to you?
As needed.
Okay, but under employee, what does it mean?
It must be an as needed employee that's called in. That's my familiarity with it. I don't know their process, but a PRN nurse is not full time. That's what it is means. It's not
Okay.
full time.
Do you know who Adelaide was?
I never met her.
Do you know who Isabel was?
I don't know. No.
That's all on this page. Let's flip over to May 3rd. Again, similar information, no new names. Let me just check. I think that may be all the names that are on there, but just to confirm, you did not know the names, who any of these personnel were that are listed as employees.
Correct.
And I admit, I am speculating a slight bit that they were providing these treatments.
I would speculate that too.
All right. If you turn to page 214, this is for 5/6/2022. There's a new name under the employees, and that's Autumn. Do you have any recollection of who Autumn might have been?
I don't know who Autumn is.
Okay. And I'm not going to go through, there's several pages more, but you didn't know who these staff members were.
No, I never met
You
them.
don't know what their qualifications were.
No.
You don't know if they were APRNs or RNs or LPNs or paramedics.
No, I do not.
That's all I have at this time.
I'm going to reserve my questions until our case in chief.
Okay, thank you, sir. Any questions by the board? Mr. Ruff?
So as a collaborating physician and you review 10 charts or 20%, did you ever come across a chart that detailed a physical exam on the patient?
Other than with Priscilla Pulliam, no.
So the other patients that you were collaborating with that were coming in to get treated, you never came across a physical exam that was performed before her.
There were no charts.
Okay. And was that not a red flag as a medical director that there were no charts with the collaborating provider that maybe something needs to happen?
That's a very good question because that's one, yeah, that's a good question. The first one, of course, keep in mind, without a long explanation, 4 different nurse practitioners. The first one never was approved, so she didn't count. The second one was getting onboarded, where a lot of these documents were that we were just recently discussing. We're all through those channels. She came on board and wasn't even practicing more than a month until we did have they had the shutdown, and that's even, you know, with Dr. Headley alluding. So they had no activity for months, is what he said in his own sworn testimony here. They never did because for whatever reason. It wasn't because I wasn't available. Trust me, I'm very available to my my nurses and who work at hospice. But for some reason, I was never told when they started back up. They were talking about getting going, and there were some things about they were trying to work into that situation. So then it was absolute silence. I wasn't getting complaints. I wasn't getting calls. I wasn't getting any reports. There was no charts being produced, as we see with this infusion model. As we just went through these charts, they weren't documentation from a nurse practitioner. So there was essentially a 10% of zero, unfortunately. There's also the other factor is that most of these patients that I was brought in for testosterone replacement, the other issue was that these patients were personal patients of Dr. Headley. That was unknown to me, but he was sending these patients to CORE, and that he was still assuming the responsibility for prescribing their medication that they got from the pharmacy. And so in those situations, he was already established with those patients. So there were no charts. And the third one, as we said, she was supposed to get started. I think we'll talk more about her in a few minutes or so, but the point is we never had an active collaborating role. And then the fourth one, then there's once again big periods of time with nobody there at all. So there was no nurse practitioner. I had no role there under a collaboration. The fourth one is really the only one that had a functioning collaborative relationship, that where she actually communicated, did the 10% charts, and that they were well done, but it was a very small volume.
So someone who's working 50 hours a week and supervising care in hospice, what was your motive and rationale for even getting near this situation?
It was in the beginning, it was just that I knew the people. My guard was let down because I knew Brent Holloway before many times coming to the office. And so I already had that professional relationship with him. He needed some help. He was asking me to collaborate. I signed things on the front end because I thought they were under the auspices that the nurse practitioner would be using those accounts, but everything would be under the nurse practitioner. The ownership issue is that I thought I was going to be initially TRT, and then over time this might expand. And that was my motivations. But what happened was that every time we had a nurse practitioner for it was just sparks, and then it would go out. There would really be no active clinical practice where they were engaged, and they were engaged with me. And then it would go dark, and then he would come back and say, "Hey, let's try it again. I'm sorry, this didn't work out." So I was not seeing the picture, and I wasn't getting the big picture. Wasn't being it was being shielded from me essentially, and that's why. That's unfortunate. In hindsight, yes, I understand now, but back at that moment in time, it wasn't clear.
That's it.
Any other questions by the board? Okay. Yes, sir. You may.
Are there any documents, emails, texts, notes of your own stating that your relationship at Core Cryo was limited to collaborating with nurse practitioners from time to time?
That's all I had, was just a collaboration agreement. I had nothing else.
Right, but is there anything else saying even though your title is medical director, this is all that means. There's nothing like that, is
Well,
there?
other than the things we've even gone over just a few moments ago, where I was expressing myself and reminding Brent that I'm unpaid, I'm doing this completely out of pro bono to help you out with TRT. And then that's it.
And again, that's about the time that it began to dawn on you, after the board had begun the investigation, that there might be a problem for you as a physician based on what Core Cryo was doing.
Just being affiliated with it. Yes.
Thank you.
Okay, you can take, oh, I'm
Dr.
sorry, did you have another question?
Yes.
You can
What is
go
your
ahead.
relationship with Brent Holloway now?
I have had no contact with him whatsoever since all of this happened. Since that email I sent that said I was in somewhere around May 2022 that I was wanted this to, I don't want you coming back with anybody else. I want to have divulged any relationship with this organization. And he said, thank you. I appreciate your help. And I never heard a word from him. I haven't seen him since.
Any other questions by the board? Okay, Dr. Sanders, you can take your seat. Mr. Barnes, do you have another witness you wish to call?
I was confirming. And I do not have another witness that I would like to call. So as complaint counsel, I rest.
Okay, thank you, Mr. Barnes. Mr. Mercier? Are you ready to call your first witness? That is correct. Yes, we can take a 10-minute break before you start your case, okay? All right, so we will reconvene at 2:40. Mr. Mercier, you can begin your case in chief and call your first witness.
All right, the licensee calls Mr. Jonathan Dalton.
Reminding you, Mr. Dalton, that you have already been sworn in.
Would you state your full name for the record, please, sir?
Jonathan White Dalton.
And Mr. Dalton, what is your position?
I'm the Director of Investigations for the State Medical Board.
Mr. Dalton, your name appears on the first amended affidavit in this case, which I'm trying to find the Bates number for it. I believe in front of you, there's a binder and it's going to be MSB 3129 to 3137. If you take a look at actually the summons and affidavit, it looks like, well, that's the first amended one. That's right. 3129 to 3137. If you take a look, you'll make sure we're on the same page once you get there.
Sure.
Folks, that's PDF 499. PDF page 499 for the board.
3131, I thought you said the page number?
I think so. Mine's
Okay.
not numbered like that. I'm going by the index that's been entered in the
This says first amended affidavit. Is that what you're reading from?
Yeah, that's
Okay.
the one I assume that's dated, sworn and notarized the 11th day of May, 2026.
That's it.
Okay.
I got you. Mhm.
And that's the one we're about here today.
Yes, sir.
The first amended affidavit.
Mhm.
Okay.
Yes, sir.
And you drafted this?
Yes, sir. Yes.
Did you have any assistance in drafting this?
Yes, sir. In the sense that, every case that comes through, we consult with our legal department and we work together through what we need to present.
And it states at the very beginning, I, Jonathan Dalton, Director of Investigations, Mississippi State Board of Medical Licensure, do hereby make oath that I have reason to believe and do believe.
Yes.
And it has a listing of paragraph numbers 1 through 10. Is that what you're looking at?
Yes, sir.
All right. So you are familiar with the allegations of this first amended affidavit, and for short, I'm just going to call it affidavit.
Sure. Yes, sir.
Okay. I'm going to ask you some questions about this, and let me start with paragraph number 3. And the very first sentence there in paragraph number 3 says that investigation determined that from approximately September 9, 2019 to May 10, 2022, licensee served in name as medical director for a business administering IV fluids named Core Cryotherapy and Wellness located in Ridgeland. Did I read that correctly?
Yes, sir.
All right. Now, is that based upon your investigation and compilation of all the documents and facts and affidavits and information gathered?
Yes, sir. I believe so.
And prior to this first amendment complaint, there had been a hearing involving Dr. Massey Headley before this board to approve a consent order on May the 18th, 2023, correct?
Yes, sir.
And you were involved in that matter as well, correct?
Yes, sir. In my capacity as director, but I didn't perform the investigation itself. But yes, sir. Mhm.
But you were here present for that hearing.
Yes, sir.
Now, when you made the statement here that licensee served in name as medical director for a business administering IV fluids, what did you mean by that?
I think I was referring to the documents where he's mentioned as medical director, probably the purchase forms.
With the documents that are in front of you there, would you look at MSB 69?
Turn right to it. Yes. Yes, sir. Go ahead.
Mr. Barnes was asking Dr. Sanders a few questions about this document earlier. If you would go down about 3/4 of the way down the page and you see where there's a paragraph indented, it says on May 10th, 2022 at 5:51 a.m. You see that?
Yes, sir.
And it says Brent starts off.
Yes, sir.
And if you would, look at that second full paragraph there. And the paragraph begins, right now, you do not have a nurse practitioner that I'm supervising. Also, I have become increasingly concerned about the current liability climate in regards to the Board of Medical Licensure. although I'm listed as the medical director, I'm really not serving in that capacity. Did I read that correctly?
Yes, sir.
Do you have any evidence which indicates that, or that would contradict what Dr. Sanders said there, that he was only listed as the medical director and not really serving in that capacity?
Nothing beyond the documents I referenced earlier that said
Well,
head medical director. Yes, sir.
Let's talk about those.
Sure.
Because I think that's important. I think the board wants to know, needs to know exactly what documents are you saying indicate that he was serving as medical director in more than name only?
The purchasing forms, I'm sorry, the authorizations, let me rephrase that. The authorizations for ordering of medications.
Okay, and that's it.
That's the ones that I can think of off the top of my head. Yes, sir.
Well, it's important. I mean, if there's anything else, I think you need to share it with the board. Is that all there is that indicates he was serving as medical director? I think I'm trying to make sure we get the facts out here.
He told him all he could remember were those documents. He proceeded to badger him about whether there weren't any more because it's important. I think that's improper and argumentative.
I'm going to sustain the objection. There are about 5,000 documents, as I understood. So, I mean, he identified a couple. You're welcome to question him on others, but I'm sustaining the objection.
I'm trying to cut this hearing down so not going to be here all day and try to get him to point me to those documents.
I understand. Thank you.
Okay. All right. Mr. Dalton, let's go through the documents.
Yes, sir.
Let's start with the index. You should have it at the very beginning of the binder there.
Yes, sir.
There's an index to MSBL's exhibits, Michael Sanders, MD. That's what I'm looking at. You got that there?
Yes, sir.
Okay. Now, that breaks down the documents in the white binder, which are the exhibits of the board staff against Dr. Sanders here, and it sort of categorizes them. So can you tell me in which categories there are documents that you believe demonstrate that Dr. Sanders was doing more than being listed as a medical director, that he was actually serving as a medical director in those categories? Or you just break it down to the category. We'll go to the categories and look at them.
Object if Mr. Mercier wants to ask the person who created these what they meant. That was my paralegal, Jack, prepared this index. And I don't believe that Mr. Dalton has ever seen it. But I think this line of question is irrelevant and immaterial.
I appreciate his testimony, but I really would like to hear from the witness.
So what is your response to the objection, sir?
It's absolutely irrelevant. How am I going to get the facts out that he says in his affidavit support his claim that my client was the medical director?
You can ask that exact question.
I did earlier, but I'll ask it again. Mr. Dalton, what are the documents that you have before you that are the board's documents that you say indicate that my client was acting as a medical director for core cryotherapy?
The ones that I am aware of and can think of are those documents I referenced earlier, and that would be the medication-related forms.
The ones for ordering the medications?
Yes, sir.
Okay. Thank you. You should have before you in those documents affidavits. They begin, I believe, with the affidavit of Justin Francis Cato at MSB 459. And I'd like to ask you some questions about those.
Yes, sir.
When you were, I'm sorry, I'll let you get there.
I'm almost there. All right, sir, go ahead.
Yes, sir. I'm going to try to cover two things at one time when we're going through these affidavits, so we don't have to go back and forth. You heard testimony by Dr. Headley when he testified here a few years ago. I'm not asking you to remember them, but you remember that hearing.
Yes, sir.
Okay. And one of the issues here before the board, whether it's directly spoken or not, is whether or not Dr. Headley was the one that was actually handling the medical side of things at Core Cryo, or whether or not it was Dr. Sanders. Would you agree with that?
Yes, sir.
Okay. So I'm going to go through here. Let's start with Dr. Francis Cato's statement of facts, which begins on MSB 459. And if you'll look at paragraph number 7, would you read that for the record, what Justin Francis Cato said in the statement of facts?
You said number 7?
Yes, sir.
Okay. I was told by Brent Holloway to not tell core patients or visitors that Dr. Headley was an owner. Patients were considered anyone receiving IV hydration therapy.
All right. Now, were you aware of that fact during the investigation of Dr. Headley?
I don't know if I was personally aware of it. I'm sure that as an agency, we were aware of it.
All right. Now, look up at paragraph number 6 above it. If you would, read that one, please.
Yes, sir. When Dr. Capel was employed at CORE, Dr. Capel would sign off on patient documentation. Upon Dr. Capel's departure, Dr. Headley began signing off on patient documentation. Dr. Headley continued signing off on patients during my employment.
Now, based upon your investigation and hearing the testimony of Dr. Sanders today, you can't say that Dr. Sanders was doing the same thing that Dr. Capel was doing at Cryo, can you?
Objection calls for speculation.
I'm asking him to contrast what Dr. Capel was doing while he was at Core Cryo with what Dr. Sanders was doing, because Dr. Capel said that he was, Mr. Francis Cato says that Dr. Capel was the medical director and he was signing off on patient forms. I'm trying to establish that it's not the same thing. It's not apples and apples.
I'll also add an objection to argumentative.
I'm a little bit confused by the question, admittedly. Can you rephrase it?
Certainly.
Okay.
Yes, sir. Yes, sir. Yes, ma'am.
Yeah.
If in looking at that paragraph number 6, it states that Dr. Capel would sign off on patient documentation. You agree with that?
Yes, sir.
In your investigation and listening to the testimony of Dr. Sanders today, you did not come across any testimony from him or any facts during your investigation that indicates that Dr. Sanders was signing off on patient documentation, did you?
Not that I recall.
Okay. Now, if you would look on the next page of that statement of facts of Mr. Francis Cato, paragraph number 10. In that paragraph, it says that all patients that were referred to CORE was from Dr. Headley. Did I read that correctly?
Yes, sir.
Now, you didn't come across any information where patients referred to CORE were from Dr. Sanders at any time, did you?
I don't think so.
Now, if you would, look down at paragraph number 12 and read that for the record, please.
Brent would order all IV hydration supplies to be used at CORE.
And that's pretty consistent with what you heard Dr. Sanders testify to today in part. Would you agree with that?
I object to the form. I don't understand the question.
Okay. I'll rephrase.
I don't know what he's
I
referring
agree.
to.
I'll rephrase that. You heard testimony from Dr. Sanders today. He was agreeing with the questioning by Mr. Barnes that there were orders placed Some were by Mr. Holloway and some were by Dr. Headley and some were by other staff members, but not by him. You heard that?
I did hear that. Yes, sir.
All right, if you would, let's look at the statement of facts of Kathy Graves, which should begin at MSB 461. Let me know when you have that one.
Yes, sir. I'm there.
All right, if you look at number 5, I'll give you a chance to read that.
Okay.
All right, in that statement, Miss Graves is saying that she was instructed by Dr. Headley to contact him with any questions regarding patients. And she goes on to say that I was told by Dr. Headley that he was available for questions that arise during treatment of clients and patients. All right. Do you have anything to dispute that statement by her that Dr. Headley told her that he would be available to discuss any issues with patients, about patients?
No, sir.
And if you would look at paragraph 8, and for the record, it reads, Dr. Headley would occasionally call me at CORE and wish to discuss business and clinical issues with him. Now, in your investigation, did you find any information which indicated that Dr. Sanders would call Kathy Graves to discuss clinical issues with her
I don't believe so.
or business issues?
I don't believe so.
If you would, turn over to the next one, which is the statement of facts of Lauren Nicole Sharp. And that should begin at MSB 464.
Yes, sir. I'm there.
And look at paragraph number 4, please. And I'm just going to read that one so everybody makes sure what we're talking about. It reads, I met Dr. Massey Headley at CORE for the first time soon after beginning employment. I was instructed to contact Dr. Headley if any questions should arise regarding the ordering of any medical supplies. Now I'll stop right there. Did you come across any information or statements by any other employees or medical professionals at CORE which indicated that they should contact Dr. Sanders if they had any questions about ordering medical supplies?
Not that I recall.
Okay. The next sentence, I was instructed to contact Brent if there were any issues regarding the cryotherapy supplies. I ordered all medication for hydrotherapy from an already established account, which I think Mr. Barnes discussed already. Now, if you look at number 6 down below, and I'll read that one for the record just to make it easy. Brielle Richardson was hired by CORE immediately after graduating from an online nurse practitioner school. I was in a meeting with Brent and Brielle when it was discussed that Brielle would require 720 hours of direct supervision prior to working on her own. Brent telephoned Dr. Headley and asked and agreed to sign a document stating that he had supervised Brielle at his Baptist-owned clinic. I was told to not tell anyone about this activity. This document was sent to the Mississippi Board of Nursing. Did I read that correctly?
Yes, sir.
During your investigation, or this board's investigation of Dr. Headley, did they investigate the 720 hours of direct supervision that were signed off on and sent to the Mississippi Board of Nursing by Dr. Headley?
As I recall, yes.
And what was the conclusion?
Those falsified documents.
Thank you. by Dr. Headley?
Yes, sir.
Now, paragraph 7, if you're continuing, the first sentence says, Dr. Headley was present for business meetings on a regular basis. Did I read that correctly?
Yes, sir.
Now, you heard testimony a little earlier when Mr. Barnes was examining Dr. Sanders about a meeting in which Dr. Sanders was taking notes. Do you remember that?
Yes, sir.
Okay. Other than that one instance that Mr. Barnes was asking Dr. Sanders about, are there any other such meetings that you're aware of, based on your investigation, that Dr. Sanders attended?
Not that I'm aware of.
If you look at paragraph 8, Dr. Headley would occasionally call me at court and wish to discuss business issues with him. He would also call me to inform court that he was sending patients for therapy. Did I read that correctly?
Yes, sir.
All right. What's your understanding of what is meant there? And if you don't know, that's okay.
Yeah, I honestly don't know and
Okay.
couldn't speculate.
All right, let's look at paragraph 9. As the general manager, and this is Lauren Nicole Sharp speaking, as the general manager, I had numerous interactions with patients and clients. Clients were defined as any person obtaining cryotherapy or who presented for the sole purpose of obtaining hydration therapy. Patients were defined as persons that received hydration therapy or hormone replacement therapy that originated from Dr. Headley's Baptist-owned clinic or presented to the nurse practitioner for hormone replacement therapy. The majority of the patients that were treated at CORE were also patients of Dr. Headley's Baptist-owned clinic. Did I read that correctly?
Yes, sir.
All right. Is there anything in your investigation of Dr. Headley in CORE Cryo that indicated that that statement's not true?
Not that I'm aware of.
Now look at paragraph number 10. I was informed by Brent that I should hire paramedics and emergency medical technicians to administer hydration therapy at CORE. Dr. Headley should be aware of their hirings as he was present during meetings when they were discussed. Did I read that correctly?
Yes, sir.
And is that statement consistent with the findings of the investigation of Dr. Headley previously?
I believe so.
Is there anything in your investigation for Dr. Sanders that indicates that he was aware that paramedics or emergency medical technicians were administering hydration therapy at CORE?
Not that I can recall.
All right, if you would, turn to the affidavit or statement of facts of Abby B. Calum, which begins at MS 467, MSB 467, I apologize.
I'm there.
If you look at paragraph 4, it says, on my first day at CORE, I met Dr. Sanders at his medical clinic in Ridgeland, Mississippi. The purpose of the visit was for Dr. Sanders to meet me and sign our collaborative agreement. Continuing paragraph 5, I met Dr. Maes Headley at CORE for the first time soon after beginning employment. Brent and I traveled to Dr. Headley's Baptist-owned clinic in November 2020 to discuss testosterone replacement therapy protocols. I was instructed by Dr. Headley to contact him with any questions regarding patients. Did I read that correctly?
Yes, sir.
What is your understanding of why Dr. Headley would tell this nurse practitioner to contact him with any questions regarding patients when she had met Dr. Sanders earlier there?
object, lacks a proper foundation and is speculative.
I can't count the number of times he asked my client what was his understanding of a statement. I'm simply asking him, what's his understanding of this? The point is, who is the medical director here? She had just met Dr. Sanders, but now Dr. Headley is saying, don't call him about the patients, call me about them. I'm asking him what his understanding is of that.
I don't know what the intent was behind this at all.
It's fair.
Yeah.
All right, look at paragraph number 8. I was informed by Brent upon hiring that clients that presented to CORE for hydration therapy were not examined by any provider at the clinic. Did I read that correct?
Yes, sir.
All right. During your investigation of Dr. Sanders, did you come across any information which indicated that he was informed by Brent Holloway or anybody else that clients that presented to CORE for hydration therapy were not examined by any provider at the clinic?
Not that I recall.
If you would, look at the next one, which is the statement of Carrie M. Golston, MSB 469.
I'm there.
All right. Paragraph 4, if you would read that one for the record.
I had interactions with Dr. Massey Headley while employed by CORE. The interactions were related to the treatment of his patients that were referred to CORE from his medical clinic.
In your investigation of Dr. Sanders, did you find anything that indicated that he was having interactions with Carrie Golston or anyone else at CORE, or that he had regarding any referral of his patients to CORE?
Not that I recall.
As a matter of fact, you did not find that Dr. Sanders referred any patients at all to CORE.
I think that's correct.
All right. Look down at paragraph number 10. And if you would read that one for the record.
I would prepare the client's requested IV solution for administration and begin the administration. IV administrations were prepared and administered in accordance with standing orders issued by the clinic provided by Brent, who stated the orders were issued by Dr. Sanders.
Make sure we're reading this the right way. The way I read this is that Carrie Golston is saying that Brent Holloway told her that Dr. Sanders issued standing orders. Is that the way you read that?
I think that's right. Yeah, I think that's right.
All right. In your investigation of Dr. Sanders for this case, what standing orders, if any, did you come across that were authored by Dr. Sanders?
I don't recall seeing any standing orders authored by Dr. Sanders.
Let's look at the next and last, I believe it's the last statement, which is the statement of Priscilla Pulliam, which begins on, I believe it's MSB 487.
Yes, sir, I'm there.
On page 2 of that statement of facts. If you would, read that paragraph 6.
On August 10th, 2021, I met Dr. Massey Headley at a CORE group meeting attended by Brent Holloway. It was my understand that before my hiring and while CORE was between NPs, Dr. Headley was reviewing labs and refilling testosterone prescriptions for patients. Following meeting Dr. Headley on August 10th, Dr. Headley referred several clients to the clinic for IV therapy, including but not limited to client WG and client RT. Dr. Headley also referred several patients for hormone replacement therapy, including but not limited to patient RD, patient BB, and patient PS.
Now, in your investigation of Dr. Sanders, did you find where Dr. Sanders had written any prescriptions for any patients of CORE?
I don't recall any prescriptions. No, sir.
In your investigation of Dr. Sanders, did you find where Dr. Sanders reviewed any labs of any patients of CORE?
Not that I recall.
If you would, look at the next page under paragraph 8.
Yes, sir.
And I'll read this. Most of my communications regarding patient care were discussed with Dr. Headley. The interactions I had with Dr. Headley were related to the treatment of his patients that were referred to CORE from his medical clinic, and in collaboration related to the treatment of my patients being treated at CORE for hormone replacement therapy. Did I read that correctly?
Yes, sir.
In your investigation of Dr. Sanders, you already testified that you didn't come across any information which indicated he was referring any of his patients to CORE. But it says here that, if I'm reading this correctly, Priscilla Pullum is saying that she had interactions with Dr. Headley relating to the treatment of the patients he referred, as well as other patients of hers treated by CORE for hormone replacement therapy. Is that the way you read it?
Yes, sir.
All right. In your investigation of Dr. Sanders, did you find any information where Dr. Sanders was having any interactions regarding the treatment of patients of Priscilla Pullum that came to the clinic?
I don't recall. No, sir.
All right. If you would, look at paragraph number 12. Here, Priscilla Pulliam says, the manager of CORE, Brooke, ordered the medical supplies that were used in IV therapy. During a visit by investigative staff of MSBML on September 14, 2021, Brooke stated that the IV therapy supplies were ordered under the authority of Dr. Headley. Did I read that correctly?
Yes, sir.
Okay. Were you there for that September 14, 2021 visit?
I was not.
Okay. Do you know who was from the board?
I could speculate, but yeah, I'm sure.
Don't speculate.
Sure.
This.
Yeah.
All right. That statement I just read by Priscilla Pulliam says that the manager of CORE was Brooke. You agree with that?
Yes, sir.
All right. It also says that Brooke stated that the IV therapy supplies were ordered under the authority of Dr. Headley. Did you read that?
Yes, sir.
Okay. Now, other than the pharmacy supply applications you mentioned earlier that Dr. Sanders had signed, did you come across any other information in your investigation of Dr. Sanders which indicated that his authority was used to order IV therapy supplies?
You're talking about like purchase forms, things like that? Is that what you're referring to?
I'm just going by what it says here, the authority. I'll use your interpretation.
Okay, fair. So I don't recall any purchase orders that were obtained. I don't know if they were requested at the time. The only thing that I know of is the communications that were discussed earlier in testimony, just some of the emails. But beyond that, no, sir.
Okay. If you would look down at paragraph number 13. During my brief employment at CORE, it was my understanding that Dr. Headley was the only physician that Brooke would contact when ordering supplies, including but not limited to IV hydration supplies and vitamins. Did I read that correctly?
Yes, sir.
In your investigation of Dr. Sanders, did you find anywhere where Dr. Sanders was contacted by Brooke or anybody else when supplies were ordered for CORE?
Other than the email communications I referenced earlier, no, sir.
Board's indulgence. All right, if you would, Mr. Dalton, turn to page MSB 496 through 498.
Yes, sir.
Could you identify for the board what we're looking at there?
Looks like a certification for monitored practice hours, maybe.
For how many hours?
It says 400.
All right, and who signed that? Collaborating physician?
Massey Headley is what it looks like.
And who is the APRN?
Abby Brielle Richardson.
And this is the document you were referring to earlier that you said was a falsification by Dr. Headley?
Yes, sir.
Do you remember this information being presented to the board during Dr. Headley's consent order hearing?
I don't remember if it was specifically presented, but I'm sure it was discussed. I don't recall the exactly what was presented all throughout that hearing.
I've got a transcript. We'll go over it in a minute.
Okay, sure.
See.
I'm sure it was.
If you would, take a look at page 495.
Yes, sir.
You see up there at the top, it says to Brent Holloway.
Mm-hmm.
And it discusses down below Abby Knight. And then it goes on and it says the very last little text message block that was sent to Brent Holloway. Would you read that one?
Yes, sir. I think. Okay. He wants everything ordered under Dr. Sanders' name, not his name. So I guess that is something between you and office manager to change for future orders.
Now, you agree with me, that wouldn't be Dr. Sanders sending that to Brent Holloway the way that's worded in the context.
It seems that way. Yes, sir.
Did you come across this information during your investigation of Dr. Headley or Dr. Sanders?
I believe it came across in the Headley investigation.
During your investigation of Dr. Headley and Dr. Sanders, what was your conclusion of why Dr. Headley wanted everything ordered under Dr. Sanders' name and not his?
Objective form calls for speculation. He's asking him to explain what a third person intended, and he doesn't have a knowledge base to answer that question.
I'm asking this investigator what his conclusion was, because one of the issues here is who is a medical director and who is not, and who is actually there on the premises doing things, and who's hiding something, and who's out front.
If you're asking his conclusion
That's right.
based on that, I'll overrule the objection. You can testify as to what you concluded from that.
Excuse me, I do have a further objection.
Sure.
The question is vague as to the time frame to which Mr. Mercier is questioning him about. there were different medical directors at different times. I think his question needs to be more specific. That's my
Mercier,
objection.
Mr. Mercier, can you make your question a bit more specific as to time frame?
Okay. We'll say during the time that Dr. Sanders was associated with CORE.
Okay, so having said that, could you just rephrase or restate your question to me?
If I can remember it.
Yes, sir.
Court reporter, read that one back.
Get used to that. During your investigation of Dr. Headley and Dr. Sanders, what was your conclusion of why Dr. Headley wanted everything ordered under Dr. Sanders' name and not his?
I don't know why he would want to do that. I don't have an answer for that. I don't know what Dr. Headley's motivations were regarding why he would want that done. I can't, it'd be speculating for me to say one way or the other because I just don't know.
As an investigator for the board, can you tell me of a legitimate reason to do it?
If the position of the business model was that Dr. Sanders was in fact the medical director at that time, it would seem that you would want to have the paperwork reflect things were being ordered under the person who's responsible for the medications. That's speculating again as to why. So now, could it be for nefarious purposes? Certainly. Yeah, I can't rule that out. Let's say that.
And you don't have any documentation or information as to what the actual business model was for Core Cryo, do you?
I believe there was documentation in the Headley case as to kind of how the business was run. But as far as to Dr. Sanders, no, sir, I don't think so.
Okay. If you would turn to page 150. Wait, let me back up. Let me get this out of the way first. Look at page 161. And I'm just going to try to get to the core of this. I'm going to let you, no pun intended. Just look at page 161 through 167. And I will ask you a question and give you a chance to look at it before you answer. My question generally is, does Dr. Headley appear to be heavily involved in the treatment, assessment, and handling of patients at CORE? If you'll look at those and tell me.
Okay. Could you restate your question now that I've read this?
Yes, sir. Based upon those text messages, does it appear to you, based upon your investigation when you accumulated these things and looking at it again today, that Dr. Headley was heavily involved in patient care at Core Cryo?
It certainly seems that way.
During your investigation of Dr. Sanders, you did not find similar evidence of Dr. Sanders having a heavy involvement with caring and treating for patients at CORE, did you?
That's correct.
If you would, now go to page 150.
Yes, sir.
There were a series of questions asked of Dr. Sanders by Mr. Barnes about documents beginning on page 150 and continuing through about 155. Are these the documents you referred to a moment ago when you said you didn't have any information regarding Dr. Sanders ordering medications other than the documents referenced previously for pharmacies? Is this what you were referring to?
Yes, sir.
Okay, just to make sure.
Mhm.
Now, in the questions that were asked of Dr. Sanders by Mr. Barnes, I understood the intimation from Dr. Barnes that Dr. Sanders, by filling out the application, may have actually ordered some of these medications and supplies. During the course of your investigation of Dr. Sanders, you did not reveal any documents or information that Dr. Sanders actually ordered any of these medications or supplies under these agreements or applications, did you?
We did not find that he had personally ordered anything. No, sir.
And that's true for all of these pharmaceutical companies.
Yes, sir. That's correct.
Now, do you have in front of you what is R1?
I do now.
I'm going to ask you to turn to, well, first of all, for the record, this is the transcript of the consent order hearing for Dr. Massey Headley conducted May 18th, 2023.
Correct.
Okay.
Mhm.
And you were present for that?
Yes, sir.
Okay. Turn to page 11 up at the top and look down line 19 to 23 and read those for the record, please. Beginning with the question.
Yes, sir. Question. Dr. Headley, you and your wife invested a substantial amount of money in this facility, CORE, when you were approached about this venture, correct? Answer, yes.
Did you find anything in your investigation which indicated that Dr. Sanders had invested any money in CORE?
No, sir.
If you would turn to the next page, page 12. And look at paragraph line 16, and I'll read that for the record. Question. If you don't mind, just go ahead and just explain how it progressed, your ownership, who was involved in the facility. Answer. Yeah, at that point, there was a medical director and there was a nurse practitioner, and that was back in like 2018. And then it just progressed from there and grew and added on nurse practitioners and different services. Did I read that correctly?
Yes, sir.
Based upon your investigation of Dr. Sanders, when did he begin his association with CORE? What year?
My recollection is 2019.
Okay. So this could not be talking about Dr. Sanders, could it?
That's yes, sir.
Right. You are aware that there was a prior medical director in name, if nothing else, at CORE before Dr. Sanders, right?
Yes, sir.
And who was that?
I believe it was stated as Winston Capel.
Dr. Capel.
Mhm.
All right. Now look, the next page, 13, up at the top, line number 4, question. Okay, so am I correct that COVID put a crimp in the operations of CORE hydrotherapy, correct? Answer, yes. Yeah, there was nothing going on for months on end. In your investigation during the Headley case and Dr. Sanders case, did you find that to be true, that the business basically was shut down for months on end?
I think that's correct. Yes, sir.
Okay. All right. Now look down at the bottom of the page, beginning line number 18. if you would, read that all the way. Well, I'll read it. I'll read it. But you would agree with me that the staff was fluid? Answer, yes. Question, it fluctuated? Answer, yes. Question, there was a lot of turnover? Answer, yes. Question, when did you officially become the medical director? Did I read that correctly?
Yes, sir.
All right. Now, you were here for that hearing.
Yes, sir.
And why was it asked in the way to distinguish being a medical director versus being an official medical director? If you know.
I don't know.
Okay. All right. Let's continue on the next page. Answer, I became the medical director in July of 22 until August of 22 for about a month period. Question, okay, and do you recall providing our investigators with a copy of the protocol for IV therapy used at CORE? Answer, yes. Question, okay, do you recall that the protocol permitted paramedics to administer the IVs? Answer, I remember that was what I was told was and had been under the previous medical director as allowable. So let me stop right there. Now, based on your investigation of the Headley case, IV hydration was being conducted at CORE while Dr. Capo was there, correct?
I believe that's accurate. Yes, sir.
Then you go again, excuse me, not you, Mr. Barnes, question, are you aware now that does not comply with Mississippi law that paramedics are not allowed to do that in clinical settings? Answer, yes, sir. I'm very much aware of that. Question, and so you understand why one of the charges in the affidavit was assisting the unlawful practice of medicine? Answer, yes, sir, I do. Question, and that was related to the people who were actually administering IVs? Answer, yes, sir, I understand. Now, in your investigation of Dr. Sanders, you didn't come across any information or evidence that Dr. Sanders knew that EMTs or paramedics, as it says here, were involved in the IV hydration at CORE, did you?
Not that I can recall.
And that's the distinction between Dr. Headley's case and Dr. Sanders' case. You agree with that? Because you did have that evidence in Dr. Headley's case.
It looks like we did.
All right, if you would, turn over to page 19.
Yes, sir.
Looking down, let me back up, page 18 at the bottom, line 24. Question, can you tell me specifically what mistakes we heard from your testimony, but can you tell the board specifically what mistakes that you feel like you made that put you in this situation? Answer, yeah, I did blur the lines between being a physician investor and a supervisor. Let me stop right there. That's Dr. Headley's testimony, right?
Yes, sir.
And Dr. Headley is admitting to this board that he was acting as a supervisor at CORE.
Yes, sir.
All right. Now, you didn't find anything like that in your investigation for Dr. Sanders, did you?
He was not an investor, no, sir.
You didn't find where he was a supervisor either, did you?
I mean, the documentation that we obtained suggested that he had agreed to serve as I'm sorry.
Go ahead. I'm going to make you go ahead. Go
Okay.
ahead.
All right.
You know where I'm going.
Sure. So the documentation suggested that he was serving as the collaborative supervisor for the nurse practitioners, at least some of them, and that he had submitted these documents that he would, that these medications could be ordered using his information. And that suggested to us that there was a taking on of that role.
We just went ad nauseum through statements by Dr. Headley and text messages where he said he's treating patients, he's giving recommendations to patients, he's telling nurse practitioners, talk to me about patient care, correct?
Yes, sir.
You didn't find anything like that for Dr. Sanders?
That's correct.
Okay.
Mhm.
So all you're saying is you had a supposition that because he had this medical director name on applications and mentioned a few other places, it was mentioned a few other places, that he was in some supervisory role. Is that what you're saying?
It wasn't a supposition that medications were ordered. That the communication suggested that he had agreed to take on this role of the role that he took, I guess. I don't think it was a supposition. The documentation we found suggested that while he may not have been as involved, certainly as Dr. Headley, maybe even minimally, if you wanted to say it that way, he agreed to allow his information to be used. He was affiliated. It seemed like he inserted himself in that way. Maybe supervisor is not the best statement to say, but that was the way this question was phrased, or the answer was phrased. But
If you have any evidence, Mr. Dalton,
yes, sir.
any,
Mhm.
that Dr. Sanders supervised anybody at CORE, please point me to it right now. The verb I used is supervised.
Supervised, no.
Okay.
Yeah.
That was my question to begin with.
Yes, sir.
Okay.
Mhm.
Now, you blurred a moment ago
Mhm.
the words collaboration and supervision.
Mhm.
All right. How long have you worked for the board?
17 years and 3 months.
We go back a long way.
Yes, sir.
And you know the difference between collaborating and supervision, right?
Yes, sir.
Collaboration by a physician of a nurse practitioner is not the same as supervising employment, is it?
That's correct.
Matter of fact, it's defined by the statutes and the regulations, primarily the regulations. Do you agree with that?
Yes, sir.
All right. On the same subject, let's turn over to page 22.
Okay.
On line 17, the question, item 5, licensee shall within 6 months of the acceptance submit approval of this order, successfully complete a board approved, continuing medical education course, specifically the CPEP probe course covering the areas of ethics, boundaries, and supervisor of mid-level providers. And the answer is yes. And what I just read is my understanding that's what was in the consent order
I believe that's
for Dr.
right.
Headley.
Yes, sir.
So in this case, the board was ordering him to at least educate himself on supervising mid-level providers,
Yes, sir.
which
And-
he
and
had
can I-
been doing.
Can I expound on that just a little bit?
Yes, sir.
So I think part of that terminology difference comes from the fact that the board licenses physician assistants, and the term used in physician assistant regulations is supervise. So I think that's how they can be conflated sometimes.
Okay, but we're not talking about that in this case.
That
are
is
we?
correct, sir.
There's no physician assistant that was involved in CORE and Dr. Sanders.
That's correct.
Okay. So let's turn over to page 25, down to line 18. By Mr. Barnes. Question. Dr. Headley, one thing I want to make sure the board understands, talking about blurring the lines. A big part of that line was responsibility for supervising mid-levels, correct? And what's his answer?
Yes.
All right, let's turn over to the next page. Well, let me back up. Start at the bottom of page 25, line 24. I'll read question. Okay. And again, while you're not the only licensee involved in the operation, there were times when you told the clinical staff, if you have questions, call me. Did you not? Answer, I did. I told them if they couldn't get in touch with the medical director to call me. I did. Question, and did they call you? Answer, on occasion, they did, yes. Question, and you did act. even though you were not in name their supervising physician, you in effect acted as the supervising physician, did you not? Answer. That was the mistake I made. Yes, sir. Now, if I'm reading this correctly, and it was your investigation of Dr. Headley, I'm reading that as Dr. Headley saying that he was not in name their supervising physician, but he did act as their supervising physician. You agree with that?
Yes, he said on occasion he did, or they did. They contacted him, yes.
And in your investigation of Dr. Sanders, I think we've already established, you didn't find any evidence that he acted as a supervising physician for anybody at CORE.
That's correct.
Let's go back to your first amended affidavit. Actually, could we take about a 5-minute break?
Yes, sir. We can break until 3:50, 3:55. Okay.
One.
Mr. Mercier, you can continue.
Mr. Dalton, I want to refer you back to the first amended affidavit.
Yes, sir.
You have that in front of you?
I do.
Okay. Now, we were on paragraph 3 a moment ago, and in the first sentence, you say that licensee served in name as medical director.
Right.
You don't have any evidence that he did anything to serve as medical director other than in name, as you say, do you?
Like I said earlier, I believe my testimony is that those documents that said medical director and the fact that there were conversations about medications being ordered, that was the kind of
Okay.
impetus for using that. Yes, sir. You're
Okay.
correct.
All right. And you said you have been with the board for 17 years as an investigator?
17 years, 3 months.
So you're familiar with medical terminology?
Fairly.
And you're familiar, you have to be familiar with the statutes and the regulations for the
Yes, sir.
medical board, correct?
Mm-hmm.
So let me ask you this, where in the regulations for the medical board is the term medical director defined?
It is not.
It's not defined in the statutes either.
No, sir.
So what is the definition of medical director? As far as this board's concerned?
Well, I can't speak for the board because, as you said, it's not defined, but I can give you what my impression of what
I'm
a
not
medical
asking your
director is.
impression. I'm asking
Okay.
for your experience in dealing with the regulations and where in the regulations I might find that definition. But if you agree with me, it's not there, we'll move on because I can't find it.
I agree with you.
We will stipulate that the term medical director is nowhere defined in the board's regulations.
The stipulation is noted. Thank you.
There are 500 plus pages of board exhibits here, Mr. Dalton. Among them, curiously, is a definition of medical director. If you will look, beginning on page 253, for some reason, these regulations are included, and I don't know why, but I did actually look at them. Beginning on page 253, it says it's the Mississippi Department of Health, Bureau of Emergency Medical Services, Emergency Medical Services, Ambulance Service Licensure. And then if you turn over there on page 261, there's actually a definition of medical director. That's item number 52. And let me know when you get there.
I'm there.
All right. I just want to make sure, because I didn't run across this, that is not the definition of medical director that you're trying to ascribe to the meaning in your affidavit, is it?
No, sir. I think this was part of the, maybe with Dr. Headley, just as it related to, I can only speculate.
I didn't know why it was in there.
You are correct, sir. That's, I don't think that's the definition that, well, there is no definition. We've already said that.
All right. Now, if you'll look on page 265, it also lists the responsibilities of the state EMS medical director. You see that?
Yes, sir.
That doesn't apply either. Not here. Not for Dr. Sanders. Not for the medical director that you wrote about.
No, sir.
Okay. Just making sure.
Mm-hmm.
Now, you say down at the bottom of page 1, however, upon review of the practice, it was determined licensee failed to follow up and review the inventory and accountability for substances ordered under his authority, substances which were also utilized by unlicensed, unauthorized individuals for patients licensee did not evaluate.
Mm-hmm.
Okay. Let's break this down. All right. So you're saying that you're talking about patients that Dr. Sanders did not evaluate, starting from the back, right?
Yes, sir.
Okay. And you're saying that substances were also utilized by unlicensed or unauthorized individuals. Who are you talking about there?
I think we're referencing back to the, maybe the paramedics, something along those lines. Yes, sir.
Okay. can you produce me
Mhm.
in these 500 pages you've got here,
Mhm.
a document which shows that a paramedic treated one of the core patients or clients, whatever you want to call them?
I mean, I would have to look through all this to see, but I don't think it's there.
Yeah, I would agree with you. It's not there. It's not included in the evidence, is it?
I mean, again, I have to look through, but if you say it's not there, it's not there.
You're the witness. This is your investigation.
Well, that is true. I didn't compile these documents, and so all I can say is that if you say it's not in there, I guess it's not in there.
Would you agree with me that if you're accusing a doctor
Mhm.
of something involving his license,
Mhm.
and you're talking about the treatment of a patient by somebody that's unlicensed,
Mhm.
there ought to be a document in the file which shows that that actually was done to a patient instead of just speaking in the abstract?
I suppose that's reasonable.
Now,
Mr. Dalton, would you like a moment to review the documents?
It's going to take a while, but I can.
And we can bring the other 5,000 back.
these are the evidence they've submitted the documents they submitted in evidence. And if they want to backtrack now and you want a continuance, I'll agree to a continuance, but I don't want to be here at 2:00 in the morning.
Well, we can proceed.
Mr. Dalton, you say that licensee failed to follow up and review the inventory and accountability for substances ordered under his authority.
Mhm.
Now, what you're saying when you say ordered under his authority, you mean these pharmaceutical company applications we talked about earlier.
Yes, sir.
And I don't really know how to phrase them or coin them or label them, whatever.
I think some of them are labels like authorization.
But you know what I'm
Yeah.
talking about.
Yes, sir.
Okay.
Mhm.
So you say he failed to follow up and review. Where in the regulations does it say he is required to do that?
Well, I'm not aware of well, there is a section in the regulations related to controlled substances, but this was not controlled substances.
All right, so that would not apply here, right?
As written, no, sir, it
Okay,
wouldn't.
so where in the regulations does it say that the licensee is required to follow up and review inventory and accountability for substances ordered under his authority?
I don't know that I was making the assertion that there was such a regulation. I think I was just making the general point that medications were ordered under his authority and he didn't check into what was being done with them.
Okay,
Yeah.
but where is the requirement that he do that?
There's not a specific requirement for
Okay.
that. Yes, sir. Mhm. It was an observation, not a statement that there was a requirement.
So you'll agree for the record, there is not a regulatory statutory requirement that he do so?
That's correct, to my knowledge. Mhm.
And looking down at the last sentence in paragraph number 4, you say further licensee signed the agreement dated January 29th, 2020 with the title medical director.
Mhm.
And when you say agreement, you're not talking about an agreement with CORE, you're talking about these pharmaceutical agreements, like it mentions above.
Yes, sir. I think that's right.
Okay.
Mhm.
There is no CORE agreement he signed that says he has the title of medical director. You'll agree with that?
Yeah, not to my knowledge.
All right. If you'll look, paragraph 5, about halfway down, you see the sentence that begins, "This was the only time"?
Yes.
All right.
Mhm.
I'm going to read that. "This was, quote, the only time I ever met or spoke to Dr. Sanders," close quote. "Despite this, APRN Graves indicates she administered, quote, hydration therapy," close quote, "to patients on a weekly basis." Did I read that correctly?
Yes, sir.
All right. You agree with me, Mr. Dalton, that an RN can administer hydration therapy?
Yes, sir. Subject to the discussion that's been had here today. Yes, sir.
Well, you're not aware of any regulation or statute that says an RN cannot administer, the word administer, the verb, hydration therapy?
If they have a valid order, I'm not aware of a regulation that
Okay.
would prevent them. No.
And you're also aware that to be an APRN, an advanced practice registered nurse, you have to first be a registered nurse.
Yes, sir.
Yeah. And so the duties and the acts performed by an MP sometimes or as an RN and not required, do not require the the nurse practitioner credentials.
Yes, yes, sir. Mhm.
All right, if you look on the look on paragraph number 7 of your affidavit. You state there, despite the fact that he accepted the title of medical director of CORE and held that title for approximately 2.5 years. And let me stop right there. We read a moment ago where Dr. Sanders had written to Brent Holloway that he was medical director in name only, and you agreed there's nothing that disputed that.
That's correct.
Okay. So he held that title in name only, not as a functioning medical director in any sense of the word.
Sure.
Okay. You say, continuing, the investigation revealed that Dr. Sanders had physically been on the premises of CORE once. During the time he was officially the medical director, licensee did not conduct significant and meaningful oversight, review, or analysis of operations, staffing levels, staff qualifications, inventories of supplies, medications, or other resources at CORE. Licensee did not sufficiently inquire, investigate, or inform himself concerning clinical operations at CORE to allow him to adequately function as medical director of that establishment. Did I read that correctly?
Yes, sir.
All right. Licensee has stated that he believed that any meaningful oversight was being conducted and provided by Dr. Massey Headley, who, along with a close family member, was a co-owner of CORE with Brent Holloway. So let's break this one down.
Sure.
All right. Based on your investigation of Dr. Headley and now Dr. Sanders, and what we've gone through in these affidavits, and even Dr. Headley's own testimony, he was, in fact, acting as a medical director for CORE in his activities. You agree with that?
Objection, vaguest to time.
While Dr. Sanders was there.
I think the record shows that there was definitely a period of time and for certain patients that he was functioning in that capacity.
Okay. Even when Dr. Sanders was, quote, not acting, but was the medical director in name only.
Yes.
Okay. So backing it up even further, you say licensee did not sufficiently inquire, investigate, or inform himself concerning clinical operations at CORE to allow him to adequately function as medical director of that establishment. Where in the regulations or statute does it state what you need to do to adequately investigate or inform yourself of clinical operations?
It doesn't. I think that's just seems prudent.
Prudent. Okay. But the board enforces its regulations, not prudence. You agree with that?
Yes, sir.
Okay. There's not a regulation that says that.
That's correct.
Okay. Have you ever investigated a medical director of a hospice or a nursing home?
We have, as an agency, myself directly, maybe in my capacity as director, kind of tacitly, yes.
Okay. So you understand that whenever you are a medical director of hospice or a nursing home, you have an agreement with the nursing home which sets out what your responsibilities are as that medical director. You've never encountered one where you didn't have that, have you?
Not that I'm aware of.
Okay. In this situation with CORE, you did not encounter or find any sort of a delineation or outline of responsibilities of medical director.
Not that, no, sir.
Is there any regulation that you're aware of that would require a collaborating physician to visit the workplace premises of the nurse practitioners with which they have a collaboration agreement? I mean, if you do, I'm going to ask you to list it for me,
Sure.
and we'll look it up.
So there is a section about quality assurance. It does not specifically require visitation to the individual's practice, though. Yeah, so no.
I'm sorry.
Yeah.
Okay. So a physician who is a collaborating physician for a nurse practitioner at St. Dominic or Baptist is not required to go to St. Dominic and Baptist and just see what's going on, are they?
No, sir.
Okay. Now, paragraph 8 on the next page. This is kind of where the rubber's meeting the road, as they say.
Yes, sir.
You agree with that?
Yes, sir.
I'm going to let you read this one for the record.
Okay. Licensee's failure to conduct significant and meaningful oversight of clinical operations at CORE or to adequately investigate same caused or was a substantial contributing cause for failure and breach of professional standards, including, among other things, IV hydration therapy being performed on patients without adequate examination or evaluation prior to such therapy, and unqualified and unlicensed staff administering hydration therapy without order or prescription by any qualified physician, nurse practitioner, or physician's assistant. Excuse me.
Now, you agree with me, Mr. Dalton, that based on your investigation of Dr. Sanders and CORE, Dr. Sanders did not have a, quote, business relationship with CORE.
Object to the form.
I'm not sure how to respond. It's pretty straightforward. Did you find anything that indicated that Dr. Sanders had a business relationship with CORE?
You mean in like a financial sense?
Yes.
No.
Okay.
Mm-hmm.
As a matter of fact, I think the testimony was that, and the documents indicate that he was doing what he was doing, lending his name on his applications, pro bono. He wasn't receiving anything.
Yes, sir.
You didn't find any indication that he was receiving any type of remuneration or anything in return?
No, sir.
So can you point me to a regulation or statute that says that Dr. Sanders, who lent his name to CORE for ordering supplies and participated in some meetings and was a collaborating physician for nurse practitioners at CORE, was required to provide oversight of clinical operations at CORE?
You're quite sorry.
Objection asked and answered.
I'm going to let him clarify his answer. Go ahead.
Okay, sure. So just so I understand your question, you're asking me if there's a regulation or a statute that requires that?
Right.
No,
Okay.
sir.
And the same thing for the rest of that sentence to adequately investigate. There's nothing like that. There's no regulation or statute that requires.
Yes, sir.
Okay. So when we get to the part of causation, you say caused or was a substantial contributing cause for failure and breach of professional standards, including, among other things, IV hydration therapy being performed on patients without adequate examination or evaluation prior to such therapy. Let me back up. Whose professional standards, what breach of what professional standards?
Well, I think the idea here is that there's medications being ordered under a licensed provider's authority that are then used by someone else in a manner that he doesn't know what's actually being done. Like,
Okay.
it's kind of, if I could give an analogy, and maybe this is, so like the NCAA, our favorite organization, they have a thing called lack of institutional control. It's kind of in that thought process. Sure.
We don't have that in these regulations, though, do we?
You're correct.
Right. And to be convicted of a crime, you have to know what that crime is. You have to be advised of it, right?
Objection. This is not a criminal matter.
And I was going there
This is
next.
stating the objection.
I was going there
Let's
next.
move on.
You will agree with me that in order for a physician to be disciplined by a licensing agency, they're entitled to know what the regulations are that they have to abide by.
Sure.
Okay. and there's no such regulation, I think you've already said, that would require Dr. Sanders to provide oversight, to investigate, or do anything else with regard to medications that were ordered under his name or number.
No, sir, not that specifically. No, sir.
Okay.
Mhm.
All right. So this was just generally, you didn't feel like it should be being done. Is that right?
I think in looking at the facts of what had transpired and the documents and what they said to me and our staff, I think it was determined that there was a serious lack of paying attention to what was being done with the medications that were ordered in his name. And he is a physician. Nobody can just order this stuff off the street. So it's important to maintain an account of what is being done with it. It is ordered in his name. And, well, I don't want to misspeak on federal statutes and that sort of thing. That's just in general, that was, I think, the thought process behind this.
All right. Are you telling this board, who are physicians primarily, that if they allow medication to be ordered under their number, that they're responsible for all the downstream use of that? They got to follow up, investigate, and see what was done with it, or they'd be up here before this board on disciplinary action if they didn't do it?
I think that if you order a medication that is something that the public can't just walk into Walmart and order, it's something that requires a professional license, you are responsible for the use of that medication. Absolutely.
So you're telling the board they got to follow up to see what the nurses and everybody else did with that medication. In the hospital, you got stuff going through a Pyxis system. You're telling these doctors they got to follow up and see what happened to it, where it went. You have nurses that steal medication in hospitals, and you're saying that's responsibility of the doctor who prescribed it or whose name it was ordered under?
Objection. Argumentative. Incredibly argumentative. And speculative.
I'm going to sustain the objection. Let's move along.
Okay, we'll move along. All right. But you'll agree with me, there's no regulation that says what you just stated.
Objection. Asked and answered.
Sustained. Let's move along.
All right. Then, Mr. Dalton, point to me in these 500 pages of documents any instance where what you're claiming in paragraph 8 was done to a patient with medication ordered by Dr. Sanders.
So I would go back to the earlier comments I made about the purchase orders. So don't have purchase orders on what was purchased specifically under his authority. We just know, to answer your question, there isn't a patient file that would.
So you can't prove it.
In that sense, no.
Let's look at count 1. And this is when I was talking about an opening, we get to the elements.
Sure.
Based on the foregoing, licensee is guilty of knowingly performing an act which in any way assists an unlicensed person to practice medicine by virtue of licensee's failure to oversee the use of medications ordered under his authority, all in violation of Mississippi Code annotated section 732529(8)(b). And you'll agree with me that section 732529(8)(b) does not state that a physician has to oversee the use of medications under his authority.
I don't think it does. I'd have to read it, but I don't think it does.
Right, it doesn't. All right, so let's talk about just the rest of this count. Do you have any evidence that Dr. Sanders knowingly performed an act that assisted an unlicensed persons to practice medicine?
I believe we do.
What did he knowingly do?
He signed the documents that allowed them to order medications and did not check into what was going on in the background.
Well, can you roll that back to him getting a medical degree? Wouldn't that be knowingly doing it too? He didn't authorize the misuse of medication, did he?
I'm sorry, you're going to have to rephrase that. I'm getting.
Dr. Sanders did not authorize the misuse of medication, did he?
Authorize the misuse of the medication?
Correct.
I don't think he authorize the misuse of, no, I don't think
Right,
so.
right. So he didn't know what was being done with the medication is what you're saying. You said that earlier.
Right, but he knew he signed over his authority and then didn't check.
Okay. All right. Now you say assist an unlicensed person to practice medicine. You already said you don't have and you can't prove that this was done in any particular instance to any particular patient. But you say to practice medicine. What's the practice of medicine?
That's it's the as it's defined, I guess, in statute.
Yeah, I have to have that statute right here.
Okay.
Let's talk about that.
Sure.
May I approach a witness? Mr. Dalton, I've handed you a copy of what is section 732533. Can you read the heading there for me?
The practice of medicine defined.
And could you read that definition for the record?
Yes, sir. The practice of medicine shall mean to suggest, recommend, prescribe, or direct for the use of any person, any drug, medicine, appliance, or other agency, whether material or not material, for the cure, relief, or palliation of any ailment or disease of the mind or body, or for the cure or relief of any wound or fracture or other bodily injury or deformity, or the practice of obstetrics or midwifery, after having received, or with the intent of receiving, therefore, either directly or indirectly, any bonus, gift, profit, or compensation, provided that nothing in this section shall apply to females engaged solely in the practice of midwifery.
In the documents you have for this investigation,
Mm-hmm.
you'll agree with me that you don't have any document which indicates that anybody providing services that was unlicensed suggested, recommended, prescribed, or directed for the use of any person, any drug, medicine, appliance, or other agency. You'll agree with me that you don't have any evidence of that, do you?
Again, I'll revert back to my other thing about, or earlier statement about what's in here, but I don't think so.
Okay, because what this is about
Mhm.
is paramedics
Mhm.
starting IVs, right?
Yes, sir.
Right, and that's not within the definition of the practice of medicine right there, is it?
It's not
Okay,
the way you phrased it. Yes, sir.
all right, if you would, go to paragraph 10 of the affidavit.
Yes, sir.
There you state that the board's administrative code, Title 30, Part 2640, Rule 1.4, states in part, quote, licensees must not prescribe, administer, or dispense any legend drug, ... without a good faith prior examination and medical indication, close quote. Did I read that correctly?
Yes, sir.
Now, you don't have any evidence that Dr. Sanders prescribed, administered, or dispensed any legend drug in this case, do you?
Not that Dr. Sanders did. No,
Okay.
sir.
If I could have the board's indulgence, I'm wrapping up.
Yes, sir.
Attend to the witness.
I almost said cross-examination by Mr. Barnes, but I think just any examination by Mr. Barnes. Go ahead.
Mr. Dalton,
Yes, sir.
does this board police any general ethical standards that are not specifically listed in the regulations?
Get to the question, calls for speculations outside the scope of the expertise of an investigator for the board, calls for a legal conclusion.
Investigator for the board for over 17 years, who has participated in many investigations and is intimately familiar with both this board's procedures and with the regulations and ethical standards of the AMA.
I'm going to overrule the objection. You can proceed. You can answer the question.
Yes, I mean, there's certainly ethical expectations that this board has of its licensees.
Is there any requirement in the Medical Practice Act that a physician not provide substandard care?
Overruled. I said objection is overruled.
I'm sorry, could you say that question
Answer the
again?
question.
Is there any requirement in the Medical Practice Act that a physician not provide substandard care?
I mean, I don't think that that's in there. I'm sorry, maybe I'm misunderstanding what you're asking. So
Are physicians required by the Practice Act to provide care that meets the standard of care?
yes, and in many places it talks about the standard of care. Mhm.
And it also, there are references to substandard care.
Yes, sir. Mhm.
Do you happen to know the medical malpractice standard applies in the state of Mississippi?
I don't know that, no, sir.
Okay. You were asked a lot of questions about specifics. At the conclusion of your investigation, based on your 17 years of experience, did you reach a conclusion that Dr. Sanders had performed any act which directly or indirectly assisted in the unlicensed practice of medicine?
Yes, sir. As I testified earlier, the signing of those authorizations and the communications related to the purchase of those IV medications. Yes, sir.
Are you aware of any, strike that. Was it difficult to create a timeline of when specific personnel worked at Core Cryotherapy?
Oh, yes, sir. I think it was. I mean, I think testimony reflected so far in fact, I think it's even quoted in here from one of the statements that turnover was fairly high.
Are you aware, Mr. Mercier has talked a lot about contract. You hadn't seen a piece of paper that says he's medical director, defines his duties. Have you seen any contract or agreement between Dr. Sanders and Core Cryotherapy or Brent Holloway or Massey Headley that says you're just the medical director in name?
No,
you
sir.
have no responsibilities.
No, sir. I haven't seen that.
Right. By way of foundation, you have investigated quite a few practices involved in the provision of IV hydration therapy.
Yes, sir.
Is it common, or in your experience, is it common for such clinics to keep poor documentation that obfuscates what was really going on?
Objection leading is irrelevant. What happens in other clinics? Calls for a yes or no answer, which makes it leading, and it's irrelevant as to what happened in this instance.
Mr. Barnes, your response?
Well, first of all, I'm leading a witness because he called him first as an adverse witness. I'm trying to perform in effect. He asked a lot of questions about Mr. Dalton's experience and what his conclusions were based on that experience. Mr. Dalton has testified that he has investigated other IV hydration clinics. I want to ask Mr. Dalton about commonalities, if there are any commonalities between any of those practices and core cryotherapy.
I'm going to allow those questions briefly. I am going to allow him to do some leading because the rules of civil procedure, the rules of evidence don't apply, and he is procedurally on, and I'm going to use quotations here, cross-examination. Okay, Mr. Mercier?
This is his witness. He cannot ask his own witness leading questions. Those are the rules. They apply to all.
I just told you that the rules don't,
Rules of evidence.
the rules of evidence and the rules of procedure don't apply. So that is my ruling. Thank you.
Mr. Dalton, in your 17 plus years of experience for the board, have you investigated other IV hydration practices?
Yes.
Do those practices generally keep clear, full records?
Generally, no.
Is it common for you to have to piece together what actually happened at the clinic through bits and pieces of the records they actually do keep?
Like I said, we are going to allow some leading because of the procedural posture or the posture that he's in. Mr. Barnes, I'm going to urge you to move along in your questioning. Thank you.
Yes, ma'am.
Yes, we often have to piece things together.
To your knowledge, was the board provided in either the Headley investigation or the Sanders investigation a complete set of medical records or client records or whatever core referred to them for all their patients?
Not that I'm aware of.
To your knowledge, was the board ever provided any purchase orders, invoices, or other documents that would specifically show the credentials in whose name supplies were being ordered?
Not that I recall.
Attended the witness.
Okay, any questions for the witness by the board? Mr. Roth? Dr. Roth?
Do we have a signed collaboration agreement?
I believe there are some agreements in evidence.
Yes, sir. There are some in the documents. I can't testify.
No, as long as there is a signed collaboration agreement between the APP and the physician. That I don't want to beat this horse anymore. I just want to know if there's one out there.
Yes, sir. I believe it's in evidence.
And then the document that you referred to, I want to make sure base stamp 151 is the one that Dr. Sanders signed in his own writing, put medical director. That's the one.
Yes, sir. That is one of them. There are, I think there's, yes, sir. I think it's just a continuation of the same document. Yes, sir.
And the last one is looking at the sideways stuff with the daily appointment list. Were we ever able to get to the fact that there was an APP in the clinic during the time of these infusions, or were they done by RNs or other professionals?
Without reviewing the Headley case file, that would be hard for me to say. I'd hate to speculate.
That's fine. You can leave it at that. I'm just wondering if y'all were aware in your investigation that in these daily appointment lists, these names that nobody could tell who they are, were they nurse practitioners? Were they just nurses? And I just want to make sure I'm not missing anything. That's it. Thank you.
Thank you, Dr. Roth. Any other questions by the board? Any re-examination by Mr. Mercier? Okay. Thank you, Mr. Dalton. You can step down. Okay. Mr. Mercier, do you have other witnesses to call?
The licensee rests.
Okay.
We don't have any rebuttal. We're ready to proceed to closing statements.
Excellent. Thank you. All right. Mr. Barnes, you can proceed with your closing statement.
Dr. Sanders affiliated himself with Core Cryotherapy willingly, going into it with his eyes open. He acknowledged that he, will use Mr. Mercier's words, he lent his name to Core to use. He gave his credentials, his NPI, his DEA number, other professional credentials to Cryo to allow them to purchase medications. And based on his testimony, he had absolutely no idea at any given time who was administering those medications. Now, the records actually, I believe there are either 3 or 4, Dr. Roth, agreements for collaboration between Dr. Sanders and nurse practitioners from time to time. But Dr. Sanders, after he did that, after he affiliated himself, after he accepted the title medical director, which his defense is that it's utterly meaningless, that no one should read anything into the title medical director, and that a physician who places himself in a position like he did with Core Cryotherapy has absolutely no obligation to act as a reasonable, responsible physician. Okay. But he did that. He gave them his credentials. He knew they were using it. He knew they were using them to order supplies. Were supplies ordered in Massey Headley's name? Absolutely they were. But Dr. Sanders fell off the map once he had given him his credentials. Dr. Sanders did not have any idea what was going on at Core Cryotherapy. Dr. Sanders says that's a defense. That's a defense that I didn't make any visits. I didn't know what was going on. I didn't know who the employees were. Is that the action of a reasonably prudent, minimally competent physician to give away your credentials and never ask any questions? You heard testimony and saw the documents that some of the nurse practitioners sure did. They started saying, wait a minute, is this legal? Can we do this? There's proof in the record that, at various times, both the nurse practitioners and others indicated that non-licensed, non-certified, non-qualified personnel didn't simply administer IVs. They, in effect, ordered them. There was a reference that the NP told that Brent said, none of these clients are given a physical examination. Now, I have certainly not said or intended to lead the board to the conclusion today that Massey Headley was a wonderful physician, that he bore no responsibility for the practice at Core Cryotherapy. Obviously, he did. He agreed to, in a public order, a suspension by this board. He was required to divest himself of his ownership interest in Core Cryotherapy, and he acknowledged his fault, which included the fact that paramedics and other unqualified personnel were used to provide IV hydration therapy. Dr. Sanders, again, his defense comes down to either he is not a reasonably prudent, mentally competent physician, or he is the most gullible, most naive person who has ever allowed his name to be used in connection with a medical practice. He doesn't strike me as that naive. The part that really drives this home for me is that over 2 years after he'd been medical director, they had a quarterly meeting, a QA meeting, which is part of the collaborative relationship required by the regulations. And then Dr. Sanders himself took the minutes or notes of that meeting and what was discussed. And what those notes show is that even at that time, after 2 years, Dr. Sanders really had absolutely no idea what the law required of a clinic performing IV hydration. The board may change the regulations to require that all patients, all clients receive a physical examination. That's fundamental to the practice of medicine, stated in our regulations many, many times. The decision was made at that meeting that Dr. Sanders at that point should start going to IV hydration meetings and learn how the practice and how the regulations work. If they'd had that meeting back in 2020 or 2019, that would have been great, right? But the fact that it didn't occur for that long and that Dr. Sanders did not feel any need to inform himself of what was actually occurring at CORE, that should not be a defense. If Dr. Sanders didn't know what was going on, it's because either he turned a blind eye or he did not want to know. He should have known. Any physician given their credentials for use by a clinic, especially one where they really admit that they have no idea what's going on, should do some minimum investigation. Now, what the board, does with this case, what the board does if there's any discipline, of course, that's within your discretion. But I would remind the board that you have heard quite a number of IV hydration cases over the last few years. The board has handed out punishments as harsh as a 1-year suspension. The board has handed out, I believe the minimum was 1 CME is the minimum punishment that was handed out. I may be wrong, but the public orders would reflect that. And I do think that any discipline, if you find Dr. Sanders guilty of anything, should reflect that and should be consistent with the scale of discipline that has been handed out in other cases based on the facts of this particular case. The board needs to remember that the primary purpose of discipline of a medical professional is not punishment. One of the primary purposes of professional discipline is to send a message to the other members of the medical community. It is to tell the medical community what standards this board expects them to meet. I'm not standing here telling you that Dr. Sanders is more culpable than Massey Headley. I don't believe the evidence shows that. But I also don't think that the evidence shows that he has no fault whatsoever and that he should be allowed to walk away without even so much as a go for an ethics course. I think if anything, Dr. Sanders' lack of knowledge about a type of medicine that he allowed his name to be attached to, his gullibility, and his naivete certainly would call for at least some education for his own benefit and the benefit of his patients. Thank you.
Thank you, Mr. Barnes. Mr. Mercier?
You want to know what gullibility is? You're looking at it because I thought there was justice. That's what I thought. I thought that as people in a civilized society, that you've got a right to be charged with something and know what you're charged with and to be able to come in and defend yourself fairly. Nobody should be found guilty or liable or culpable of something that they're not aware of, and certainly when there's no evidence to support it. There's something called gilding the lily. I learned about it a long time ago from someone, from an accountant in New York, actually. I remember it. I didn't know what it was. Had to go look it up. Well, when you've already got something that's perfect and good, and then you try to improve on it, it's kind of like the other day, I was trying to clean the silverware at my house and had it clean. Let me go again. Oh, gee, I just messed it up. Well, that's what you had with the Headley and Core case. You had it right. And now gilding the lily is messing it up. It's tarnishing it. This is what my client's charged with. Dr. Sanders is charged in this affidavit from the board by Mr. Dalton. This and nothing else. Nothing about collaboration with a nurse practitioner. Nothing about spilling coffee on the boss. Nothing about anything to do with anything else other than what is in the four corners of this document is what he's charged with. Gullibility is not charged in this right here. And I'll even submit to you, there is no regulation that says that you can't be gullible to be a physician or a lawyer for that fact. The biggest thing is there's a definition here of medical director that the board's investigator admits it's not defined in the regulations. That's what this is all about. Oh, he was a medical director, so he should have done this, he should have done that. It's not the law. The law. It's not there. They cannot point to a single statute, a single regulation that he violated as a medical director. It's just what they, in their opinion, want to say he should do. That's very subjective. You can't be held to a subjective standard that's not defined, that you can't go look up and read. That would be pandemonium if that were the law. According to the board's own investigator, I asked him ad nauseum, what regulation was violated? None. None. Can't say there was one. Can't say there was one. Well, not specifically. Nothing. No. There was no violation of a regulation. He even admitted there was no evidence of a single patient, not one single patient, that received medication that was ordered under Dr. Sanders' name and administered by a paramedic. Zero evidence of that. But that's what this case is about. There is zero evidence in the record. No testimony, no documents. Mr. Barnes wants to talk about his character, his personality, and say he should be held liable for that. His knowledge, he should be held liable, found to be disciplined or be disciplined because he doesn't know about IV hydration therapy. But there were supplies ordered under his name because of that. That's not the regulations. That may be what he wants. That may be something that the board may want to do at some point in the future, but that is not the law today. That's not what it says. The charges in the affidavit are not supported by what I said at the very beginning, substantial, clear, and convincing evidence. It's quite the opposite in this case, quite the opposite. You have to strain to find liability, which is what Mr. Barnes is trying to do in his closing argument. He's straining to try to find something that he can hang his hat on to say that Dr. Sanders should be disciplined. It's not in this case. We went through count one. Based on the foregoing, the licensee is guilty of knowingly performing an act which in any way assists an unlicensed person to practice medicine by virtue of licensee's failure to oversee the use of medications ordered under his authority, all in violation of Mississippi Code annotated section 7325 29(8)B. That's what he wrote. And he admitted a few minutes ago on the witness stand, that's not what the statute says. Those are his words. That's not what the statute says. And when you start even breaking it down, using his words, what did he knowingly perform? What was the act? Well, he let medications be ordered, which certainly we do things in our life, but we don't expect it to be that some fraud be committed by it. And we're not charged with following up on everything we do, expecting it to be done properly to make sure that it's not done improperly. We're not held liable for things like that. So we get down to assist or unlicensed persons to practice medicine. Well, yeah, I gave him the statute on the practice of medicine. He agreed with me that what we're talking about here, what these paramedics did, is not defined as the practice of medicine. But that's what he's charged with. This case has problem after problem after problem. Count 2. Based upon the foregoing, licensee is guilty of prescribing, administering, or dispensing medications without a good faith prior examination or medical indication. List the regulation there. Well, I asked him, what evidence was there that Dr. Sanders prescribed, administered, dispensed medications, period? There are none. So there was no requirement by Dr. Sanders to have a good faith prior examination or there be a medical indication. It's not there. Count 1 should be dismissed because it's not the statute as written and the elements aren't met. Count 2 should be written. The board's investigator admitted there's no evidence of prescribing, administering, or dispensing medication by Dr. Sanders in evidence. Count 3 is the catch-all. Based upon the foregoing, licensee is guilty of unprofessional conduct, which includes being guilty of dishonorable or unethical conduct likely to deceive, defraud, or harm the public, all in violation of Mississippi Code annotated 7329-8D and 7325-83A. Once again, there is nothing there. Mr. Barnes knows that the evidence is not here. That's the reason he told you to make an example out of Dr. Sanders and send a message to other members of the medical community. He knows he's not guilty. He knows he's not culpable or liable here. But he's hoping that you will try to correct some void in the regulations or enforcement of the regulations when it comes to IV hydration therapy by punishing Dr. Sanders, somebody that's innocent in this thing, because you've already punished Dr. Headley, and you let him off light. The reason you let him off light is because you didn't hear the whole story in this hearing. I've watched the entire video. Now, I've got the whole transcript. You've got it there. All these things that you heard these nurse practitioners tell you about Dr. Headley, go look at his transcript. It's not there. You were not presented with that information. So y'all went light on him. So now they want you to go heavy on Dr. Sanders to make up for going light on Dr. Headley. So let's add a little bit more to it. That's called gilding the lily I was talking about. Do not make an example out of an innocent man. If you do, that's called being arbitrary and capricious. When you're arbitrary and capricious, you do something without reason or judgment. Here, if you find the discipline is warranted, it is without reason or judgment based upon the evidence in this case. These charges should be dismissed. Thank you.
All right, thank you, Dr. Sanders, Mr. Mercier, Mr. Barnes, for your participation and cooperation in the hearing today. This now concludes the hearing, and I will turn this over to Dr. Gibbons.
Thank you, Ms. Hartzog. At this time, I'll entertain a motion. Okay, so we have a motion to close and go into executive. Okay, do we have a second?
Second.
Okay. Any opposed? Any abstentions? Okay, we'll go into. Oh, we're now in closed meeting. All in favor?
Aye.
Okay, any abstentions? Objections? Okay, motion carries. We're in closed session. Okay, we got everyone. Okay, we're back in session. Dr. Roth, would you kindly review the decision?
In the hearing of the case of Dr. Michael
Oh,
Lawrence.
sorry. You're on this, sorry.
In the public hearing in the case of Michael Lawrence Sanders, the medical board on count 1 finds him innocent, count 2 innocent, count 3 hung, count 3 was a hung, was vote 4-4 vote. So by precedent of that, that will also be an innocent ruling. I'd like to turn it over to our president now to address Dr. Sanders.
Yeah, so Dr. Sanders, we heard a lot of testimony today. One of the concerns, or several concerns that the board has, even though you've been found not guilty on 3 counts, or several things. Number one is we strongly recommend that you look at how you do your nurse collaboration. Okay, so, I know you're involved in hospice now, but you want to look closely at the rules and regs that we have as far as supervision of nurse practitioners or APRNs underneath your watch. The other concern was clearly record keeping. So on all, patient interactions, you should be, cognizant, aware of the recommendations regarding proper documentation. And in this, particular situation, I think there were some options or opportunities missed with just having proper record keeping, because ultimately we're charged with the safety and well-being of the patients of Mississippi. In addition, you want to be careful about your use of, or the allowing entities the use of your DEA number, NPI number, supply orders, and all of that, because that, whether you want, it's under your, authority. It's just like giving the keys to a 5-year-old and, to drive a car. And well, I don't know, you're ultimately responsible with how those items are used in the medical profession. So those are just concerns that the board wanted me to express and relate to you. I'm certain you'll take those to heart, but moving forward, we just want you to keep that in consideration. Yeah. Yeah. So we'll have to, yeah, so that concludes the hearing in your situation. So you may just be dismissed. Thank you.
Make a motion for the board to adjourn the meeting? No?
We've got,
With business, I'm sorry,
Yeah.
I'm sorry.
so we'll need to go into, right.
To close the meeting, to go into, to consider to go into executive session.
Right.
Second.
Okay.
All in favor?
All in favor?
Aye.
Aye. Okay.
To go into executive.
That in there.
Okay.
Dr. Roth, would you please report?
In terms of the investigative subpoenas, number 2025-10 was approved. Number 2026-076, approved. 2026-080, approved. 2026-001, also approved. Those four. Thank you.
Okay. Thank you, sir, for that report. Last order of business, next meeting is scheduled for Wednesday and Thursday, September 16th and 17th. If you can mark your calendars, and then also check your calendar for our licensure board retreat, which is during the week of MSMA. The actual date is, yes, August 2nd and 3rd. I think those emails have gone out already. So hotel.
Sorry.
Yeah. Okay. Right. Yeah. Dinner on a Tuesday evening, and then the retreat is that following Wednesday morning. Correct. Right.
And if I can remind everybody, if you hadn't already told Frances what you need as far as hotel reservations, please make sure that you email her or call her tomorrow. And if you haven't taken that survey, that is for review at the retreat. So it's really important that we get that done. So thank you.
September 16th and 17th. So September 16th is a Wednesday, 17th is a Thursday. I'm sorry?
I will say we are trying very hard to get back to the old schedule of executive committee on Wednesdays at 1 and the full board on Thursdays.
Yeah, I'm fine with that.
Yeah, and so that's what we will be working. That's the plan, to have that schedule. Opposing counsel could not be here tomorrow, and so we wanted to get this one behind us, and so that's why we moved this one and did everything on a Wednesday this time. But we're trying to get back to the old schedule. So, and I will ask that just for informational purposes only, everybody go ahead and look at November. I will not be able to be here the current date that it is scheduled for, which is the typical third Wednesday and third Thursday. And so I'd like everybody to consider moving it up to the second week in November, Wednesday and Thursday.
So I'm looking, which is fine, that November 11th is Veterans Day. Are we open? Is that a national holiday? Are we closed or anything? Yeah.
We'll be doing it all on Wednesday. Thursday.
Okay, on Thursday then. Okay.
Well,
so November 12th then. We'll do it one day.
Yeah.
Okay.
We'll try to make sure that happens, Megan. We've got a lot. And so the way this shakes out is we get a lot of charges out there. When I say a lot, I mean 4, 5. And then you get your continuances. And of course, we had a continuance today. And so you start lining all those up. And then the closer it gets to D-Day, the more willing people seem to get to sign consent orders. And then the meeting starts shrinking down. So, I would just tell you, forecasting right now, I would think that we probably can get all the business done in one day. I would prefer for that one day to be a Thursday instead of a Wednesday. But that's just a forecast. If for some reason, like you just saw how long that hearing took, if we had 2 hearings, it would be almost 2 full days. Like we would be back in the situation of having to move executive committee to 8 a.m. on Wednesday, starting full board at 10 on Wednesday with the plans of using full board on Thursday also. That, like I say, things just tend to shake out, but it doesn't mean that they always will. And just like Dr. Owens today, anytime you don't sit for the full hearing, you're not allowed to deliberate and take part in the decision making. So that would be the only thing.
giving the opening convocation address at Swanee for the fall.
You mean just because you're chair of the board or something? I mean,
Gotta get out. and get there. Fortunately.
that's a nice honor.
Yeah.
Yeah.
You still gotta get a car.
Oh, yeah. No, I was kidding.
Oh, we'll try to make it.
Probably can't get there.
Congratulations. That's really
Yeah,
nice.
that's what happens when you're the big cheese.
About that. I think they may,
Yeah.
be sorry to get that.
Mhm.
All right.
All right, then, motion to adjourn?
I don't think we even need it.
Right. At least we're official.
Thing that they.